Well, hey guys, welcome to the recap of my really long day today. Oh, today was a marathon and we're only just getting started. So, of course, I'm going to tell you everything about it. But as I've been doing, I'm just going to go ahead and start off by giving you the 10,000-foot big takeaways from today. Here is what happened in Delphi, our first day in Carroll County in the courthouse there in the case of State versus Richard Allen. Here's our major takeaways. Judge Gold granted the state's motion in limine to exclude the composites and presumably any reference to them. That has been granted. They are out. We are not going to see the sketches. There have been no new bombshells evidence-wise in the case, and the bombshell that we had before, the hair, kind of got a little bit deflated today. We learned that the hair does belong to a female and that it is probably a relative of Libby's. So not quite the interesting side direction the case could have taken. We did, of course, see the opening statements today. There were very good and very bad things about both sides' arguments. I shouldn't say arguments. They weren't arguments. They're statements. Judge Gold reminded us about that. I'll get to it. We had testimony today from the first few witnesses from the state and absolutely heartbreaking testimony from Becky Patty. That's Libby's grandmother. I will tell you about that. And then the other sort of carnival-related news of the day was that we had 4 members of the traditional media that were banned and had their cameras seized because they were photographing the jurors on their way into the courtroom. Very explicit no-no. So, yeah. Long day, guys. Let me tell you all about it. I got there at 3:30 in the morning. Very early. I thought I was doing so well. And I was the 21st person in line. 21st person in line. We weren't sure when the day started exactly how many public seats were going to be allocated. It's just we get different information. It goes back and forth, heard everywhere from 20 to maybe up to 30. And so that was all a big mystery until about 7 o'clock. One of the bailiffs arrived and made an announcement outside that there were 24 public seats. So I scooted in really by the skin of my teeth, but I did in fact make it barely by getting there at 3:30 in the morning. I've seen since then, apparently people were starting to line up the night before, like 8:30 the evening before. Lots of chairs, people sleeping outside in the cold. Yeah, it's going to be that kind of scene. And we have Judge Gold to thank for that, for not releasing those audios the way that the law requires. Because, of course, if we could all just listen to the audio recording of the trial, we wouldn't have to line up outside the courtroom and take up their parking and cause all of these other inconveniences that she seems so unhappy about. So we had a very long morning in line. I got to meet lots of people. This was honestly like, it was a little, I mean, I'm just going to, some of you that I met in line today are probably watching the stream. I had so many people come up to me and recognize me, acknowledge my work, say very kind things to me. And I'm not used to it. It was a little bit overwhelming for me, but certainly very, very awesome at the same time. Got to give a special shout out to number 20 in line, Mr. Clinton, my friend. We had a long morning together, lots of chats, several hours in line talking about all kinds of things. But Mr. Clinton left at the lunchtime when we broke for lunch. He didn't come back for the afternoon session, and he was so kind as to give me his seat cushion. I didn't bring one. What I have is I have a down jacket that has a stuff sack, and so I don't know. I thought I was being economical. I would just wear my coat in the morning because it's really cold in the mornings here, and then I would just sit on my stuff sack. It worked, all right for the morning session, but could have been a lot better. Well, that seat cushion was really a nice upgrade, and then I got to use my stuffed sack for back support. So I ended up being pretty comfortable in these old, very old school wooden, hard, uncomfortable torture chairs. So thank you, Clinton. You are the real MVP. Definitely helped make the afternoon a lot more tolerable. Met a lot of other wonderful people in line. I got there just about the same time Lawyer Lee did. So she was right behind me and also made it into the courtroom. Bob Mata made it into the courtroom. So you should have some good legal eyes to be able to watch for your recaps for today. The courtroom in Court Wayne in Carroll County, it's similar. It reminded me of the one in Fort Wayne. Just stylistically, it's another of these classical courtrooms with the coffered ceilings and the columns and things like that. It was just, from my perspective, much more tasteful. I just liked it a lot more. It was more restrained than what was going on in Judge Gold's courtroom up there in Fort Wayne. It's got these lovely like teal blue and kind of a steelish gray blue type of accent on the coffers. It had this 3-panel stained glass skylight up in the ceiling. Just very, very nice looking courtroom. They had this little library in the back that was honestly really cool. Like these 2 little bookcases, and they're full of all of these old-fashioned bound, like old-fashioned looking bound books, but they're not actually old books, because some of them were clearly, by the subject matter, quite modern. But they were all books about like trials and justice and things like that. So, I mean, everything from the trial of Mary, Queen of Scots, the Scopes trial, trial of Ehrenberg, the Nuremberg trials, trial of Joan of Arc, Jerry Falwell versus Larry Flint, the Wounded Knee trials, of course, very interesting to me. I could sit and read that book. And then more recently, the O.J. Simpson and the Scooter Libby trials. So the jurors will not need to be bored. There is plenty there for them to sink their eyes into. They had a small law library in the back too, which I found a little bit. I found a little bit entertaining because it had 2 collections in the law library. It had a partial copy of the Federal Reporters, the second volume, second edition of the Federal Reporter. They're on the Fed Third now. But the Fed Second was there on the shelf. And then they also had a set of the Federal Rules decisions, which just seemed like an odd choice of authority to have in a state court that doesn't apply the federal rules. But nevertheless, that's what they had. So that was pretty much our courtroom setting. I was I was in the back, like I said, kind of barely made it in, scrambled for a seat. So in the morning, I was in the back corner behind the prosecutor's side. I was able to switch sides after lunch and move over to the other side. It's still hard to hear, but just for a little bit different reasons. They don't have any amplification in the courtroom, just like in Fort Wayne. The acoustics aren't anywhere near as bad, so they have more dampening, but then that has its own issues if people don't speak loudly. So a lot of the testimony in particular today, Ms. Diener handled for the state, and she is quite soft-spoken. Many of the witnesses were quite soft-spoken as well. So I did have to strain a bit to hear what was going on. I don't think I missed anything major, but, can't really make any promises on that. So when we first got into the courtroom, the judge gave us the announcement about the press, the press being booted, a couple members of them. We learned that the parties had stipulated to some foundational issues so that they aren't going to have to call certain witnesses to basically lay foundations for certain pieces of evidence. I suspect these are likely things like business records, where you just bring in a custodian, the person who is in charge of the record keeping. You typically, to establish something as a business record, you have to establish is made in the ordinary course of business and around the time of the events in question, and just for ordinary business purposes, the types of thing that they rely on. And so there's just these things that have to be established to meet that foundation. So that was stipulated to, and we won't have to get those kinds of witnesses. That will save us a lot of time. And Judge Gold did thank both counsel for their stipulation to that. So yeah, she gave us the announcement. She gave us the names. I'll just go ahead and share them with you. A guy from NBC named Eric Arnold, a guy named Brian Delaney, a guy named Alex Martin, and a guy from the AP named Mike Conroy. They were apparently filming the jurors as they entered the building. The sheriffs observed it. This is not anywhere even close to the gray area of the courtroom decorum order, flatly not allowed. So the sheriffs confiscated their cameras. They took 5 still cameras and a video camera. They took the SIM cards, they took the batteries out, and they are apparently keeping them. At least for the short term. And those 4 reporters have been banned from the courtroom for the rest of the trial. So fortunately, no consequences to the rest of us for that type of behavior. But we, did get I wouldn't say a talking to in direct, in open court, but she gave us the details to make it clear she expects us all to mind our P's and Q's. She did make a comment that it's important that Mr. Allen get a fair trial without the nonsense of the media that's been going on and is continuing to happen. So, we know about the nonsense of the media. I mean, they got themselves kicked out in Idaho. So it's just, unfortunately, a little bit more of the same as far as the seeming inability to be able to follow the rules. For those of you who are on the Mr. Rozzi tie watch, he had a sort of light pink, almost a salmon kind of colored tie today with white shirt and a blue suit. Very, very nice looking. He was sitting next to Mr. Allen today, who was in sort of pink, light purple shirt. This is actually the first time that I remember distinctly seeing Mr. Rozzi just sitting and conferring with Mr. Allen one-on-one. Usually it's Mr. Baldwin that's speaking with Mr. Allen. So I did see that this morning. And that is in part because Mr. Baldwin is who gave the opening statement for the defense. So he was pacing a little bit before court came into session. I'm not going to say he looked nervous, but he just looked like he was kind of getting in the zone, getting prepared. I can relate because I myself am a pacer. I call it peripatetic lawyering. If those of you Greek nerds out there with me recognize that, it's the peripatetic school from ancient Greece. The Aristotle and his students, basically, they would walk around. They wouldn't have their classes like in a classroom. They would just walk around in public in the square. Walking, peripatetic is like a word for walking around in Greek. So peripatetic lawyering is a whole style. Mr. Baldwin does it. I do it myself. So he was doing quite a bit of that. I think just getting himself kind of comfortable. So then she announced that she was granting the motion in limine on the composites. She gave no details about the reasons for that ruling, just saying that she was memorializing it in a written order. So we'll probably see that show up on the docket if it has not already. The ruling on Mr. Tobin remains outstanding. She, as part of that motion, she was provided with a deposition, some CDs. She indicated she hasn't had time to review that, and by 2 a.m. she decided it was better for her to get rest than to soldier through that. So she did say she will have that tomorrow, which gets me to a point that it was not clear for quite some time whether we were going to have court on Saturdays. So originally, when this trial was set, and there were concerns about the length, the defense had expressed concern that the length of the trial wasn't going to accommodate the time that they would need to be able to present the defense case. At that point in time, Judge Gohl had indicated that they were going to go ahead and go on Saturdays as well. Then the trial ended up getting reset. It's a little bit longer now. So it wasn't clear if we were going to expect Saturday court or not. Well, now we know they are anticipating we're going to have half days on Saturdays, so from 9 to 12 o'clock. This is only going to be an issue for me for tomorrow. I'm not going to be able to be there tomorrow. I am going to be flying back to Washington because may sound, I don't know, you can tell me if you think this is a good reason or not, but we got this girl at my gym, guys. We've been working with her for a while now. She's having her first fight. I can't miss it. I can't miss it. I got to fly back for that and help work in her corner. So, Robert, Dora, if you guys are watching, she's going to kill it. Like, I can't wait. She's going to do so awesome. She's so ready. I'm really excited for her. So it's going to be a very quick fly back, get up early again tomorrow to drive to Indy, fly back, go to the fight, and then fly back here on Sunday, get back around midnight. And then I may very well have to just drive directly to Delphi to get in line at the courthouse. Yeah. Well, I'll be ready for it. I'm fortunately very skilled at being able to sleep on the airplane. So they are expecting that ruling tomorrow, per Judge Gohl's announcement. Judge Gohl announced that we would not be let back in the room if we left during the proceedings going on, so we would get locked out. That's not particularly unusual. It's fairly routine. It does get to be distracting if people are coming in and out of the door all the time. So that, good rule to know, but wasn't particularly surprising that would be the case. So the jury entered, and the first thing I noticed was that the gentleman who originally we thought was the last one selected, supposed to be an alternate, but then had been seated with the jurors, like the regular jurors, the regular 12, this time he seemed to be in an alternate seat. They've got him lined up where the jurors are in the box, the 12 are in the box, and then there's 4 seats in front with what I'm assuming are the four alternates. It looks like they're sitting in a specific order and not just like coming in and picking their own seat. So I guess that guy is an alternate and not one of the jurors. This whole process has been enormously confusing. But we did kind of get to see them and get our first view of them taking in the process, taking in the arguments, taking in the first bit of the evidence, gauging their attentiveness and so forth. So they were read the preliminary instructions, nothing really extraordinary in there. I did make a couple of notes of things that I thought were interesting in those instructions. For example, there was one instruction, it's consistent with the legal principles. It was just, I've never heard it spelled out quite this explicitly, and so it caught my attention that if the evidence is susceptible of 2 reasonable interpretations, you must adopt the interpretation that favors the defendant. So that was kind of interesting. They got to give him the benefit of the doubt if they're not sure what to believe, not sure what inference to draw or something like that. Reiterated this distinction in the language between if you find that there is insufficient evidence to convict, then you must vote not guilty. You must vote to acquit him. But if you find there is proof beyond a reasonable doubt, you may vote to convict him. So it's just a fascinating distinction. I actually had an attorney from Indiana reach out to me and explain that this derives from a provision of the Indiana Constitution that does kind of seem to reserve the right of the jury to decide what the law is. And so normally the distinction is the jury decides the facts of the case, the judge decides the law of the case, and there's a hard line between them. So the jury's job is just to take the law as the judge gives it to them and apply it to the facts as they find them from the evidence. So that's kind of what prevents, you know, the jury from engaging in nullification if they follow that rule. Indiana apparently provides some kind of leeway for the jury to decide maybe we don't agree with what the judge says the law is, that they also have the right to decide the law. So very interesting distinction. It's one I'm, if I get some time this weekend, I'm going to have time on a plane. You know, I got a million things on my list that I'm thinking about doing, but that's one of them. I would love to dig into that a little bit and see if I can get a little deeper understanding of that distinction and that nuance, because it really fascinates me. It's so different from just the rule that we have in Washington. Washington's very clear. If you find them beyond a reasonable doubt, you must convict. Like they no leeway. No leeway. It's your duty to accept the law as the court gives it to you. A lot of instructions along these lines. They should attempt to fit the evidence to the presumption that the defendant is innocent and the presumption that the witnesses are truthful. So that I also thought was kind of interesting. Attempt to fit it. So if there's different ways to interpret it, got to give the witnesses the benefit of the doubt, but got to also presume that it's consistent with the defendant being innocent. They have to have a reason for disregarding the evidence if they're not going to consider something or include it in their decision making. They can't just do that arbitrarily. I don't like that piece of evidence. There needs to be a reason why they think it's not credible or not entitled to weight or something like that. Not going to get transcripts of witness testimony during deliberations. This varies state by state, but some places you can get a read back or something like that. We saw this in Karen Reed as well. No ability to go back and review the witness testimony. So they are very dependent on their notes. They were provided with pads and pens for them to be able to do that. The jurors are allowed to ask questions. They've already done that today. So I'll talk about that when we get to it. Gave a little bit of instruction about the process. So after they go through the attorney questioning, the judge asks the jurors if they have any questions. The jurors are to raise their hands and write down their question if they have one. They give it to the bailiff. Bailiff gives it to the judge. Judge discusses it with the attorney to confer on whether the law allows that question to be asked. And if it is, they will ask it. If not, they will not. So I did appreciate that she explained that process to them so that it's clear. The question is whether the law allows it, not is some party arguing against it or not. Like it's not going to fall on one side or the other. The jurors have no obligation to discuss the reasons for the verdict after the case. They're not precluded from it, but they don't have any obligation to. And then this other little interesting twist that is just very different from Washington. I think I've never seen a rule like this in another jurisdiction, where they're not allowed to discuss the case, but they can discuss the evidence before they go into deliberations, like during recesses and stuff like that, as long as everybody is present and as long as they don't form an opinion. So I guess they can say things like, I don't know. I guess if you're being really strict, you can't even say, wow, that was weird, because, that was weird was an opinion. I don't think that's probably quite as strict as they mean. They just mean don't decide guilt, don't decide critical issues until all of the evidence is in. But just this very different exception to the rule I'm used to, that you say nothing. You may not talk to the other jurors about what's going on in court until you are in that jury room for the deliberations. And it's just to keep that process confined and keep it clean. So little different. Little different in Indiana. They will let them chat about the evidence all together as long as they don't form an opinion. Mr. McLeland gave the opening statement for the state. He gave a very good opening. Gotta say, he gave a very good opening. That said, it started off very inauspiciously. They have a extremely large TV screen there in the courtroom to display the video exhibits, digital evidence, and so forth. So Mr. McLeland had wanted to play a video, not exactly sure which one, maybe the bridge guy video, not totally sure. He wanted to play it for his opening, but they couldn't get it to work. So after they fiddled around with it for approximately 5 minutes, they gave up and he just went ahead and proceeded to his opening. It was largely a recap of what he gave in his mini statement, even down to his theme, right? He says, a few days ago, I told you this case was about bridge guy, a bullet, and the brutal murder of 2 young girls. So repeated that theme, didn't have a new one to replace it. I was wondering that in the morning when we were waiting outside. I'm like, you know, he kind of burned that statement. Is he gonna have a new one, or is he gonna just try it again? Well, he found a way to recycle it by just saying a few days ago I told you that. So it just served as a reminder, but he got to repeat it. And now he was going to give us the rest of the story. So there wasn't a ton of detail that he added, but I'm going to just go ahead and cover the basic facts that he outlined in the opening statement. He anticipates the evidence is going to show. So February 13th was an unseasonably warm day. They had the day off school, and so Abby and Libby decided to go to the Monon High Bridge. These trails are part of a bigger system in Delphi, go through town, go out through the periphery of town. And the Monon High Bridge is an abandoned train trestle about 60 feet above Deer Creek. They had asked Kelsey German, Libby's sister, to go with them, but she couldn't because she had work. So instead she drove them. And while she drove them, Libby was sitting in the front seat. Abby was sitting in the back seat. Libby was snapping some pictures. She took a selfie that ultimately ended up in evidence. We were able to see that. Libby and Abby were dropped off at what they're calling the Mears entrance to the trail system. The trail system has all kinds of different entrances, and so when I went out to the trail system and walked out to the bridge, the Mears entrance is basically between, it would come in and meet the trail between where I started and the Monon High Bridge. So a little, like, not quite halfway down that trail. Abby and Libby were best friends. They were more like sisters than friends. Abby didn't have a phone, only Libby had a phone, but she had set Abby's fingerprint to be able to use Libby's phone. So that's how close they were. They were both at Delphi Middle School. On the day they went down to the trail, Libby was on the phone. She was posting to Snapchat, texting, looking at photos. The Monon High Bridge is a very high, very old, very long bridge. Once you're on it, there is nowhere to go. It is high, there's no rails, it's long. You would have to jump off or something, and that's, you know, not going to be good for your health. The ties are also very old. There are some loose and some missing. So it is very scary to cross and downright dangerous, but kids like to do that kind of thing. Libby was using her phone while they crossed. She took a photo of Abby that she posted to Snapchat. Libby was crossing the bridge first, and then Abby was coming behind. So as they got across, they looked back, and as Libby got across, she looked back and she saw that a man was following Abby, and she had a bad feeling about it, according to Mr. McLeland. So she decided she needed to film what was happening. And this took place at 2:13 p.m. The man followed them off the bridge, pulled a gun, and ordered them down the hill. They comply, and at that point, the video cuts off. It's a little bit of a description of what's there on the video. Derek German, Libby's father, was supposed to pick them up, and he arrived at the trail to pick them, but they were nowhere to be found. So eventually police were called. There was a search that went until about 2 in the morning before it was paused, resumed again at about 6 a.m. Both were found later dead just upstream from the Monon High Bridge. It was a gruesome scene. Libby was completely naked, covered in blood. Her throat was cut in several places. Her blood was on the ground, and it was on a tree that was nearby. Abby was wearing her own underwear, but wearing Libby's shirt and jeans. She was wearing shoes but no socks. And the rest of the girls' clothes were found in Deer Creek. The sole exception was one shoe, which together with Libby's phone was found underneath Abby. And then they found, of course, an unspent .40 caliber Winchester bullet between the two girls. So the phone was taken for processing. They recovered the photos and the video of the bridge guy. So witnesses then began to come forward. There were 3 girls that were on the trail that day that had taken a picture on the bench east of Freedom Bridge, which is a bridge that's on the trail. I went across Freedom Bridge to get to Monon High Bridge from the Mears Trail. You would not need to go across Freedom Bridge. It's already past that point. So they reported running into a man on a trail who was walking with purpose, and he was not friendly. And Mr. McLeland says that was Bridge Guy. Another witness, Betsy Blair, she had walked up to the Monon High Bridge, saw a man out on the platform. This is also Bridge Guy. And then finally, Sarah Carbaugh reported seeing a man walking on the side of the road, muddy and bloody, like he had just slaughtered a pig. And according to Mr. McLeland, this is also Bridge Guy. Years passed, and at some point, somebody was reviewing an old report by a DNR, Department of Natural Resources officer, who spoke with Richard Allen in 2017. He told the officer he'd arrived at the trails at 1:30 and left at 3:30, and that he ran into 3 girls. The Sheriff Liggett thought that if they could find the man who had run into the 3 girls, that would give them Bridge Guy. That's who it was, the man who was walking with purpose and was not friendly. So this led them to call Mr. Allen and interview him again. In this interview, he said he was wearing a blue or a black Carhartt jacket and jeans. They searched his home, where they found a gun with a .40 caliber gun, and found the clothes, and they found several knives as well. They tested the bullet, and according to their testing, of course, it came from Richard Allen's gun. So they interviewed him again, and Mr. Allen had no explanation for how his bullet got there on the scene. He was arrested, and then while incarcerated, he told investigators what they already knew, that he had killed Abby and Libby. He gave details of the how and the why. This was not the product of interrogation. These were volunteered, spontaneous statements that he made. The admissions had details that only the killer would know, according to Mr. McLeland. So he closed by saying that the killer had hidden in plain sight for 5 years, and that you will be firmly convinced that Richard Allen is the man on the bridge who killed Abby and Libby. He was going to have his way with them, but he was interrupted, forced them across the stream, and killed them. So that's the broad outline of the state's theory of the case. We then got Mr. Baldwin. Mr. Baldwin told us that Richard Allen is completely innocent. That's how he started. That was a theme that he hit on throughout his opening. He said there will be reasonable doubt from the evidence and from the lack of the evidence. He asked the jury to wait. That assured them that the defense wanted the truth to come out in the courtroom for both the jury and for the families as well. So the truth, according to Mr. Baldwin, is that the investigation was messed up from the very beginning and up to as recently as the last few days. So back in the beginning, evidence was lost. Key witness interviews were gone forever, and they didn't even write down the names of the people that had been interviewed. So there was no way to recreate some of these early investigative steps that police had taken. About a month later, they lost more. A period from about April 29th to June 2nd, they lost more interviews. During the middle of their investigation, they got into a turf war with the FBI and kicked them out. The problem is that the FBI had been assisting with the digital extraction from Libby's phone. And so the police kicked them out, kicked the FBI out before discussing the FBI's findings from that extraction. Then 2 days ago, Mr. Baldwin tells us that law enforcement is scrambling because there's a hair in Abby's hand. This was the hair that we heard about for the very first time in this mini opening statement. He gave us a little bit more detail that it was wrapped around her fingers and it had a root. So DNA was extracted from it. The analyst testified that the hair might be from a relative of Libby's. It's not Libby's hair and it's not Abby's hair, but it is female. So they need still to complete the testing. When we're in trial 7 days later, it's a little bit incomprehensible, 7 days, 7 years later, that they still need to test mom, grandma, sister, or somebody like that to be able to tell us if it's a family of Libby or somebody else. So in 7 years, they never turned in the grandmother, Becky, Patty, or Kelsey German's DNA to try to match it. They had the DNA, didn't turn it in. So we don't have the result back yet, and we are hoping to get that result back. Now, part of the defense theme is that the truth can come out on a phone. He had a phone that he would continue to show the jury. He says the forensic data on phones doesn't lie or cheat. And so when you find out what is on Libby's phone, the state's case is going to start to fall apart. So he's said there were a couple of guys from the Idaho State Police that were in charge of analyzing the phone dumps and the data, but they were ill-equipped to understand it. And it's important because this phone data is accurate and reliable and is going to be incredibly important. He asked the jury to hold the state to their theory of the case because he contends they are going to have to change it as the evidence comes out. It's not going to be able to be reconciled with the state's theory. So according to the state's theory, he recaps it for us. According to the state's theory, Abby and Libby were dead by 4:00 p.m. at the latest on Monday, February the 13th. They don't move. The phone doesn't move. They are killed and abandoned and left in place. And that the phone was left under Abby's body the whole time from 3:30, 4:00 p.m. until the time that the bodies were discovered about noon the following day. So Richard Allen arrived at the trails on the 13th. He parked at the CPS lot. We've kind of seen on a map now where that is. It brings them a little bit, you follow the road to get to the Mears trailhead and then follow the Mears trailhead out to the bridge. So it's a little bit further down. The trail itself runs parallel to this main road, this big county road 300 north that goes in the area. So he drove in an abnormal way, parked past Mears at CPS at 1:30. This again is the state's theory that he went away, took a route that there's no real obvious or good reason why he would take that route, parked at the CPS building at 1:30. And according to the state, the car is parked there until sometime after 4 o'clock when he left. And then once he left, he didn't come back to the crime scene. He didn't take Libby's phone. So the defense theory is that Richard Allen was never on the trail at the same time as Libby and Abby. The witnesses describe a bridge guy, as being 5'11". Does not fit Richard Allen's description whatsoever. Apparently doesn't fit his description in other respects as well. According to the defense, Mr. Allen was gone from the trails by about 1:30, that he got there about noon or 12:30 or so. And that his car is gone by 2:15 p.m. And so if his car is gone, then Richard Allen is gone. So Betsy Blair is important because when she drove by the CPS lot at about 2:15 that afternoon, there's a camera, a surveillance camera in a private facility, this place called Hoosier Harvest Store. We heard a description. It's kind of a grain storage silo and cattle silage, like when they cut down like the old straw and stuff like that, I'll feed that to cattle. So warehouses to store that. This is Hoosier Harvest Store. They have a camera that has captured vehicles that go by on that section of the road. So she will describe the vehicle that she saw at the CPS lot at 2:15, one vehicle. She said, "My dad had a Mercury Comet in the 1960s. It's an old-timey car, very angular, has crisp lines, and that it looked just like her dad's old car." Richard Allen drove a 2014 Ford Focus that looks absolutely nothing like an old Mercury Comet. So Richard Allen was gone by then, is the defense theory. And the state doesn't know how to account for that. So what happened to the girls? Mr. Baldwin described that Becky Patty, the grandmother, lives with her son, Derek German. They describe what they did earlier that day. They had breakfast, they talked. Kelsey, Abby's older sister, Libby's older sister, drove Abby and Libby to the trail. And the camera shows Kelsey dropping them off. It shows her like right around the time that she had dropped them off. And so that was at 1:49 p.m. The girls came onto the trail right after Betsy. So they basically followed Betsy Blair down the trail to the bridge. And it was about 2:05 when they got on the bridge. They passed Betsy Blair as she was coming back from the bridge. So he agrees the bridge is long, high, dangerous. It's got holes and gaps in it. Like, this thing just sounds absolutely terrifying to cross, honestly. And close to halfway across, Libby was ahead, turned around, took the photo of Abby at 2:07. At 2:13 is the abduction at the end of the bridge. It's caught on video. According to Mr. Baldwin, it's not very panoramic. You won't see much. Like, you don't see the water. You don't see the end of the bridge or something like that. You hear the voice saying "girls down the hill." But the man on the video's mouth doesn't move. And so the defense is going to contend maybe more than one person. So at the end of the bridge, when they get to the end, you have the choice to go right or left. So they went left, which takes them down a steep incline. And we don't actually know. He says we won't actually be able to show, which way they went down. But either way, at the bottom there is an access road, and it goes under the bridge, under the Monon High Bridge, all the way up to the home of a man named Brad Weber. So, possibility that there was a vehicle or other people or something like that that were making use of this access driveway. And Mr. Baldwin says the evidence suggests the girl may have gotten to a vehicle down there. So I don't know what evidence that's going to be. May just be inference, but potentially a vehicle was there in that driveway. He says there's really not strong evidence about what happened. The data from Libby's phone showed that she was connecting to the tower and receiving texts and messages and so forth until 5:44 p.m., at which point the phone no longer connected. Then at 4:33 a.m., it suddenly reconnected. So the defense theory is this is when the phone came back into the area after about 10 or 12 hours of being out of signal range, basically. So this was, the phone was supposed to be under Abby's body the entire time under the state's theory. Seems to think they won't be able to account for that, the issue with the connection. So after 4 p.m., when Richard Allen left and never came back, according to Mr. Baldwin, the data will show that human hands handled the phone. Don't know what that means. Maybe somebody tried to fingerprint access something. Don't know, but the phone registered human hands handling it. And at that point in time, Richard Allen was at home and he had never came back. So they contacted AT&T to ping the phone. And again, the last ping was at 5:44 p.m. before the phone disconnected. They continued to try to ping it every 15 minutes. Around 10 o'clock, Mullen, the investigator, contacted a gentleman from the ISP named Mitch Walker, who is the ping guy. And his explanation for what was happening with the phone was that it was either not working any longer or it's out of the area. So when they recovered the phone, it was in working order. That means what is left is that the phone was out of the area, and that's the explanation for the lack of pings. It was 4:33 a.m. when it reconnected. Nobody's going to know exactly where it was when it reconnected, but it came back into the area. So the defense theory is that somebody brought the girls back down to where they were found into range. And at that time, 15 texts populated onto the phone once it reconnected, texts that hadn't been able to go through while it was out of range. And so sometime after somebody killed the girls and they put the phone under Abby's body. The defense alleges that the girls were not where they were found on the 14th, the day before, and they're relying on the search party to establish that. So the search party was assembled very quickly because it was not like Libby to be late and to not let people know where she was. So the family acted quickly. Word went out on Facebook. The search party grew. They had different areas. They have a gentleman named Fire Chief Sterrett, I believe is the name, where his part of the search was near the area where the bodies should have been. And but across the creek, not actually in that spot, across the creek. So just across from the bridge, about 300 yards from the bridge at a little bit of an angle. And so they were doing a grid search. People were supposed to spread out on the sides. Chief Sterrett will apparently testify that he saw flashlights from people searching on the other side of the creek from him where the bodies were found. And also where they were found was a flat area. It was a natural place for people to walk if they were out there searching like in the dark and just kind of taking the path of least resistance. You'd probably take the flat spot. So Sterrett doesn't know for sure where they were. They're not going to, try to oversell that, but just a lot of flashlights over in that general area. The state found the clothing in the creek, the searchers were preparing for the worst. The possibility that the girls had fallen, drowned, or something like that were going to be found in the creek. And so many people were looking along the creek. They should have seen the clothing. It should have been there, but nobody saw it. One of the Detective Holman will say that from where the girls were found to the bridge, you would be able to hear voices on the bridge. And there would have been 4 people walking on the bridge during the time of this abduction and murder, very close to the bodies, and they heard nothing. They heard no screams, they heard no talking, they heard not even any rustling like of footsteps. I will say it is extremely rustly out there when I went for my walk. Not just your own feet on the ground, but there's all kinds of little squirrels and deer. And I mean, I saw like 3 deer just in this little half-mile area. All kinds of wildlife out there snapping branches and making rustling noises. So it's very difficult to move around quietly out there. The witnesses did not hear anything, according to Mr. Baldwin. So he turned to address the bullets and the confessions. He says, first, none of it matters with the phone data showing otherwise. It doesn't matter. If we rely on the hard data, then this other stuff is insignificant. First, to the confessions, we're going to see videos of Richard Allen in his cell where he was watched 24 hours a day, the conditions that he was in, described the size and the setting of the cell, and that Mr. Allen went into prison fragile to begin with, and that these videos are going to be upsetting. Within 2 weeks of being brought into prison, he was telling an uncle, don't give me money, don't hire a lawyer, maybe I'll just admit to all of it so you don't have to suffer. And then it was about 6 months later that the confessions, he started to make these confessions where he said he shot the girls, except they weren't shot. And of course, we've heard that the defense experts will say that all of the ingredients were there for these to be false confessions. The magic bullet, he's describing it, this is the defense term for it. The magic bullet was found in the ground. There was no photo of or video or anything of the bullet being recovered, being retrieved out of the ground. There's just apparently a single photograph of it being in place, and then nothing else until the bullet is in the lab. So, you know, don't see the process of it being removed from the ground. Very interesting piece of information. The law enforcement in this area commonly used .40 caliber ammunition, and that they commonly have Sig Sauer brand firearms. They're very common. So it's possible that police dropped a bullet, but nobody asked. It's possible to test the police officers' guns, but that didn't happen either. Brad Weber, the homeowner who lived on the far side of the creek at the end of the driveway, also had a .40 caliber Sig Sauer in his vehicle. They tested that gun, and it was not excluded as being the source of the bullet. Now, this really just gets back to this whole issue with the ballistics that I've been going on and on about, you know, since this case really captured my attention. Because if we are going to say the science is so good that we can identify this bullet as coming exclusively from Mr. Allen's gun, that means by necessity we can exclude the rest of the universe of firearms. They could not have produced it. Only Mr. Allen's gun can have produced it. But lo and behold, upon testing, we can't exclude this other .40 caliber Sig Sauer that happens to be in the neighborhood. Does tend to undermine the testing a little bit in my eyes. The test itself, he indicated they'll call Dr. Warren to be critical of the testing process. So he described a little bit of the process. The bullet had markings on it, but it had not been shot from the firearm. It had merely been cycled through, but it had sufficient markings on it to be able to do an analysis. Problems sometimes with something like an unspent bullet is it might have It might have a mark on it, like from the magazine or from loading, but it's just not enough to be able to distinguish it from other guns, from other markings. You typically need a combination of things: the firing pin, you know, the markings from the ejectment. I mean, just stuff like that that will help them have more points of comparison. So it had sufficient markings on this bullet to be able to make a comparison. So the testing, what they did for this process, they took a pristine bullet and they cycled it through Richard Allen's gun, just like they would. Their theory is that this bullet would have been cycled through his gun. And the problem is that pristine bullet the process produced markings that were not sufficient for a comparison. So it didn't create a like type of exemplar. So they then fired the bullet to try to get more markings on it and see what happened. Once they fired the bullet, then they're able to compare the markings on the shell casing to the bullet that was in the ground. And so based on that, that's why they're saying they can match it to Richard Allen's firearm. But the problem is these are not apples and apples. These are apples and oranges that are being compared because the bullet on the ground had never been fired. So the cycling was not enough to produce the markings that were present on the bullet found in the ground. Mr. Baldwin also says that our own eyeballs will be able to look at the photographs of these two bullets and tell us that they don't match. He described very quickly subclasses, the idea that any manufacturer is going to produce guns that will make similar markings because they're similar makes. They have similar mechanisms. They're probably made on the same machines and stuff like that, like we talked about yesterday. So in many ways, lots of markings will be consistent between guns. So he argues that the magic bullet is of no value. He brings up Melissa Oberg, the analyst who is no longer with ISP, but will testify that she has done over 1,100 or 1,300 comparisons, and she has never been wrong, but the other people that she has supervised, they have. She's peer-reviewed their work. They've made mistakes, but she never did. So according to the defense, they, the state, have a magic bullet, but we have other evidence. We have the hard evidence, and he's showing the jury the phone at that time. He argues the timeline is not on their side. So according to Mr. Baldwin, Betsy Blair arrives around 1:49 p.m., which is right before Kelsey drops the girls off. When she got to the bridge, the guy that they're claiming is bridge guy is 50 feet away. And that guy is described as early 20s, maybe 30, with brown, fluffy hair. So Richard Allen has worn his hair short since 1989. He was in the military, and that is his preference for how to wear it. Also, the most really notable thing about Mr. Allen is he's so small. He is very short. Betsy said nothing about him being short. And so likewise, the car doesn't match the description. They are setting up the stage that this is the killer, this person that Betsy Blair saw, who doesn't match Mr. Allen, and the car doesn't match Mr. Allen. He described Betsy Blair and Sarah Carbaugh as bookends. Betsy Blair saw Bridgeman at the beginning of this incident where the murders would have taken place. Sarah Carbaugh saw him at the end, and it's supposed to be the same guy. The defense is alleging that Sarah Carbaugh's story is inconsistent, that when she first spoke to police in 2017, she said the guy that she saw had on a tan jacket and was muddy. And that was the extent of her description. In 2019, after the bridge guy videos had been released and people had seen that, the still photo and the video, at this point, she has now changed it to saying the man she saw had a blue jacket and he was bloody like he slaughtered a pig. So pretty big inconsistencies if that is the case. So, according to the defense, if the man that Betsy saw was not Richard Allen, it blows apart their theory. And likewise, if Sarah Carbaugh, if the man she saw is not Richard Allen, or if they didn't see the same man, the timeline doesn't work. So there's no DNA of Richard Allen's at the scene. There's no social media connection with the girls or with the scene, no digital connection with the scene, no forensic data connecting him to anything. It's taken the state 7 years to figure out whose hair is on her hand. Mr. Baldwin is clearly highly offended by this. Forensic pathologist is going to say that it looks like there were two different blades that were used. There was a serrated blade and there was a non-serrated blade. So Mr. Allen, in his confessions, claimed that he had killed the girls with a box cutter. But the defense theory is that this is supportive of evidence of more than one person being involved. So the multiple knives, the down the hill, voice not being matched by, the man's lips moving. And he says you'll understand when you see the crime scene that it's highly unlikely one person could have done it. So at this point, Judge Gohl interrupts Mr. Baldwin sua sponte, meaning no objection from the state. She just does it on her own to tell Mr. Baldwin he's veering into argument, that the purpose of the opening statement is to inform the jury of what they should anticipate the evidence is going to show. It's not an opportunity to argue what they should think the evidence means or the conclusions that they should draw from it. So she gave him that little admonition. Mr. Baldwin continued, it's a bizarre scene. There's sticks on the girls, and that originally when police were investigating, they thought that more than one person did it, that it wouldn't be feasible for just one person to commit this crime. So he concluded by saying, please wait, that Richard Allen is really innocent. Really innocent. So I had some thoughts about both parties' opening statements. Mr. McClelland's, as I said, I thought he delivered it very strongly, and he did provide some details that I wasn't satisfied that the defense's opening statement adequately addressed. He did certainly tell a good story, and the way that he tells a story in real time, yeah, it sounded compelling. It sounds like they have a strong case against Mr. Allen from a kind of emotional standpoint. You can sort of feel this pull of persuasion of, yeah, that sounds good, and that sounds like him, and that's the story. The bullet matches his, and then he confessed to all this stuff, and he knew details they didn't know, and he had the right type of clothing, and he was on the trail at the time. All of that, he was able to deliver in a way that made it very compelling. The defense, I thought, did a very good job of kind of highlighting the differences between their theories and some of the flaws that they expected to be able to point out in the state's theory of the case. So to kind of foreshadow for the jury what they will need to be paying attention to. Obviously, Betsy Blair is going to be a very important witness for the defense. Mr. Baldwin used her name a lot. He wants the jury to remember Betsy Blair's name. But there were some issues I thought that potentially could have been addressed a little bit more strongly. For example, the car. Betsy Blair said, it looked like a Mercury Comet. Rick's car doesn't look like a Mercury Comet. It doesn't rule out a borrowed car, or something like that. So it's part, but I think it got much stronger when he pointed out that the description of the man Betsy Blair saw doesn't have any type of resemblance really to Mr. Allen at all. The defense did not rebut the allegation the state made that in his confessions, Mr. Allen provided details that only the killer would know. He didn't get into specifics about what those were, and so it's hard to say sitting here right now the significance of that, because some details can be sort of innocuous, easy to guess. Other details might be more specific and more compelling if somebody knows that, and not the type of thing that you would know offhand. Um, the circumstances of how those details were provided is going to make, for me personally, that's going to be a big issue. That's going to matter a lot, because if he is telling them a whole bunch of wrong things before he tells them the right thing, well, this just looks more like guesswork or leading him down the path to get to where he's saying what they want him to say. And obviously any type of feeding of information or suggestion or something like that from the people that he's talking to, that would be a big problem in terms of keeping that strength intact. But if they are able to show details that he confessed to that are distinct and that were not public, that's going to be very damaging, no question about that. So I will be interested, very interested, to see how those details end up fleshing out. We did get a recess, so Judge Gohl is going to be far more generous with the recesses now that we have a jury. Now that she has a jury to take care of, we will get our 15 minutes in the morning, our lunch break, and our 15 minutes in the afternoon. But it's still very quick, you know, not a lot of time. So the first witness that the state called was Becky Patty. This is Libby's grandmother. Stacy Diener handed all of the direct examination for the state, except for the very last witness of the day that Mr. McLeland handled. So Stacy Diener handled the examination of Becky Patty. I'll give you my first impression of Stacy Diener. I mentioned she's a little soft-spoken. It's hard to hear her, especially then she's also facing the witness away from the audience, and so really, really straining to hear some of the details of her questions. From a style standpoint, she's really leading, and it's not going to matter yet. Like, they're not objecting, they're not calling her out on it, because it doesn't matter at this point in time. But if they get to a point where it matters, it could potentially be a problem. Sometimes when an attorney gets in the habit of being very leading with their questioning, it's hard to shift if they get called out and figure out how to get to where they want to go through an open-ended type of question. That's basically why people end up leading, is because they're thinking this is where I need to go. So they just kind of start there and ultimately, you know, put it in the witness's mouth. So you're not supposed to do that on direct. You don't get to lead on direct. You're supposed to ask open-ended questions. If the defense decides to start objecting to that at some point, assuming that Judge Gohl will sustain an objection like that, which is kind of a who knows at this point, then she's going to have to shift her style, I think, pretty significantly from what I saw today. Becky Patty was heartbreaking to watch. She really was the entire time. She is still grieving. It's very, very obvious. This was very painful for her. Her demeanor was flat, short answers, typically, not really expounding and volunteering a lot or anything like that. Just even with, you know, the state, who's ostensibly friendly, you know, supposed to be there advocating kind of for the victims. So it was just hard. It was hard. It was really hard to watch. She was suffering going through this. So they described the background, the family, everybody who lived together with her and her husband, Mike, the two granddaughters, Kelsey and Libby, that came to live with them about 10 years before, about 2007. So when Libby was about 3 years old. Also Derek, Libby and Kelsey's father, Becky's son, and Becky's other son, Cody, was also living with them. So that was everybody that was in the house. She worked as a home appraiser and had a home office. Kelsey and Derek were both working for her at the same time. I'm sorry, not Kelsey, her daughter. Her daughter is named Tara. So Tara and Derek were both working for her at the time. She worked every day, just regular Monday to Friday, 8 to 5 types of hours. Had been doing it for about 15 years as of 2017. Libby was in 8th grade in 2017. Described her as very active, very smart. She did math bowl. She would have graduated a year early. She did sports, band, volleyball, swimming, softball, busy girl, soccer. Pretty much year round, she was always doing something. So her daughter Tara had 2 boys, 2 sons that were the same age as Libby, her cousins. So they were very close, did everything together, went to the same school and stuff like that. She had a big circle of friends. She would spend the night with them. They would come over to her house. So Becky got to know a lot of Libby's friends, including Abby. Abby was a close enough friend that the German family took her on spring break vacation with them. We learned later it was down in Florida. So very close, spent the night frequently. Moms knew each other and communicated and so forth. So that year, Abby and Libby, they were both in the band. They both played volleyball together. And Libby had just turned 14 in December of 2016. When Kelsey got her license, she would help out a lot. These are very busy girls. They need rides all the time. So Kelsey would help out a lot with driving them around. Becky gave her a car. It was a cream-colored Bonneville. That's a boat. And so on Monday, February 13th, it was a typical work day for her, but it was not a typical school day because they had the day off. And so normally Libby would not have friends sleep over during weeknights, during school nights, but because it was a day off, Abby had spent the night at their house the night before, Sunday night. So they had breakfast. Libby was asking if they could do something. So she offered to pay the girls to help her do some filing, and then she would take them shopping. Kelsey said that she had to work, but Libby wanted to go out to the trails. So Becky told her you would have to get a ride home. She then came out to speak with Becky and told her that her dad Derek had said that he would come and pick her up. So she got permission to go out to the trails. So she came out to the office. Libby came out to the office to say goodbye to Becky, and Becky told her to take a jacket because it's warm, but it might get a little bit cold. And so the last thing that Libby ever said to Becky was, "Grandma, I'll be okay." It like even makes me tear up a little bit. "Grandma, I'll be okay." They had just gotten a puppy, and Libby had been sitting there on the floor holding the puppy, playing with the puppy. She was wearing a tie-dyed shirt and gray sweatpants. Becky didn't pay attention to what Abby was wearing. She couldn't identify that. So they knew that she meant the High Bridge Trail because there's trees out there. Kelsey is a photographer and likes to take photos out there. They had always felt like it was a safe area, didn't have any concern about taking the girls out there on their own. They used to ride bikes out there together. Currently the path has been developed. It's got asphalt on it, but at the time that was not the case. It was just gravel. So the girls would always ask permission to go somewhere. Libby would always ask permission. She wouldn't just take off. She was very respectful of making sure that people knew where she was going to be and when. So she had a phone so that when her practices were over and stuff, she would be able to get into touch and let them know when she needed a ride and stuff. So lots of people were pitching in around the house with getting everybody to where they needed to be. So fully expected that Libby would have her phone with her on the trail because she always had it with her. She never left it. She never let it run out of charge. So she made the arrangements for her father, Derek, to pick her up. She made those with him. Becky was not part of that process. So that afternoon, Derek was working with Becky in her home appraisal business. He needed to go out and take photos of some houses that were like comps for an appraisal that she was doing in an area called Frankfurt. It was going to take some time, take a couple, 2.5 hours maybe. So he told Libby he would pick them up when he was done. And they left for the trails around 1:30. So Becky knew that the kids had taken pictures on the high bridge. She hadn't seen it for herself, but knew about it. She hadn't been out there herself. She knew that it was a trestle bridge, but she didn't realize how high it was, and she was surprised when she saw it. But she was not surprised that Libby would go out on that bridge because Libby liked adventure. When they were on their vacation in Florida, she wanted to go parasailing. She wanted to try anything once. She was describing Libby's character a little bit as being polite, but she would not be afraid to tell somebody if they were out of line. She had very good interaction with adults. She was very, very smart. Becky said she had more reasoning powers than I had as an adult. She was calm. She would say, I need to be a psychiatrist because all my friends come to me with their problems. She was a logical thinker. She loved crime shows, particularly one with a red-headed surgeon. I was trying to think of what this was. I have no idea what it was. I wondered if she was talking about Bones, the one with the forensic anthropologist, maybe. I don't know. If there's a crime show out there with a red-headed surgeon, let me know what that is. It didn't ring a bell for me. But she liked that show, and she said, I'm going to do that. I'm going to help people solve crimes, or I'm going to heal people. That was important to her because her mom had died of COPD. She had good tuition, according to Becky. And so Becky's husband, Mike, is a first responder, and he had always told the girls to be aware of their surroundings, be situationally aware, pay attention to your instincts and things like that. So she heard stuff like that a lot, and that was ingrained in her. She would call if her plans would change or if she was going to be late or something like that. She was very good about notifying them. So about 3:30, then Derek called Becky and said, Libby's not answering her phone. He's here to pick her up, and she's not here. Can you try her? So Becky tried to call, tried to text. Nobody was getting an answer. And this had never happened before. They knew Abby didn't have a phone, and this just was off. They knew that this was off, so they decided maybe they needed to go look for them. So Becky called her husband, Mike, told him they were going out to the trails to look. Cody came and pulled up as well. And so they parked at the trails, and they knew if the girls had maybe decided to walk home, there was basically 2 ways that they could go. So they checked those routes first. The girls were not there. So they went to the Mears trailhead and parked. When they got there, Becky called AT&T and was on the phone with them a while to see if they would ping the phone. She said they would not do it. So she described the Mears trailhead a little bit. There's a farmhouse across the street, a small parking area, that there were a couple of cars there. And when they walked around for a little bit and didn't find the girls, that's when they decided to call AT&T. So at this point, it was starting to get dark. It's after 5. Mike said, we need to call the police, and they were concerned because Libby is afraid of the dark, and it was getting dark. She doesn't remember if she walked all the way out to the high bridge. She remembers her grandson, Aiden, Tara's son. Libby's cousin was there too, but nobody was found. She tried to call Abby's mom, but wasn't able to reach her. So she told Mike to call the police and said she was going to the house to try to find her, to Abby's mom's house. So to get there, she would not have passed the camera at that Hoosier. I already spaced the name of it, the store, the grain silage and everything. So she went to she tried to call Abby's mom's uh, phone, didn't reach her. Don't remember if she left a message. So when she got there, the grandfather was there, who said that Anna was at work. So Anna Williams is Libby's mother, is Abby's mother. So she went to the workplace and called. Anna called while she was on the way there, and they said to go to the police station. So they all met up at the police station, and police asked for a description. They asked for photos. She said she had last seen them at the house, believed them to be out at the High Bridge trails. She described what they were wearing. She's very specific about black Nikes, that Libby was wearing black Nikes. Later on, she became aware. She originally said she was wearing gray sweats, but realized she wasn't, because she was cleaning up her room and she found the sweats. So she realized that she had changed at some point in time and didn't know. But her black Nikes she wore all the time. They were at the police station until well after midnight. When Mike came back, they went back out to the trail. They drove around, continued to look. She lost track of her own car, not sure what happened to it in this whole process. They're continuing to try to call Libby's phone over and over. She went and got what AT&T records she could from the family's phones and shared them with the law enforcement. Just got them online and shared them. At some point, they went home and went back out early the next morning. They met up at the firehouse, where they were divided into groups. Each group had a leader for them to be able to do a grid search. So then the groups were assigned an area to search. Becky's area was just right down the road from her house. So again, just like if the girls had tried to get home, they were searching in the fields out in that area, just in case something had happened or they had gotten overlooked. They were away from the trails. So she was walking back to her car after they had searched that area when a friend came up and said they found them. So she ran to her car and she drove in her car over to the Mears trailhead. She ran up to a fireman and said, "Take me to Libby." And he said no. So she turned around and she saw her sister Melissa was crying. And she ran up to Melissa and said, "Hey, they found them." And all Melissa could say was, "I'm sorry, I'm sorry." And she wouldn't tell her anything. So Mike came out and they went back to the truck. He sat her down in the truck while he went to talk to somebody. And Becky, at this point, she's confused. She doesn't understand why nobody's talking to her, why they wouldn't take her to her. Oh, man. And she saw the coroner's van go by, and that's how she knew. That's when she realized. Oh my God, it broke my heart. It absolutely broke my heart hearing that. So they called the family up to the firehouse then and told them, formally that Libby was passed. It had not even crossed her mind when they told her initially that they found them. Oh man. So Mr. Baldwin didn't cross-examine her extensively. None of the family members were cross-examined extensively at all. He's basically just getting into their personalities. Was Libby the type of person who would stand up for herself, stand up for others, tell you what she would think? Would she speak in a loud voice, or things like that? He asked her about seeing flashlights out looking for the girls. And also confirmed that at some point she had been told about the hair found in Abby's hand, but she didn't remember the timing. She didn't remember if it was before Mr. Allen had been arrested or not. And she confirmed that just 2 days ago she provided DNA. She had provided it before, but she provided it again 2 days ago. That was Becky Patty. Stacy Diener did a short redirect where she clarified that the flashlights that Becky Patty reported seeing during the search she was by her own house. She was away from the trails, and that she saw some while she was driving and in the area of the CPS building and the highway, but she wasn't in the area where she would have seen flashlights near where Abby and Libby were found. She also confirmed that her husband has long guns, he hunts, and that people in the family do own handguns, but Libby was not around them. She didn't have exposure to them. After Becky Patty's testimony, we had our lunch break. We got an hour for lunch. However, we in the audience were informed that the line to get in, the line for the seats, it was going to reform after lunch. And so basically what that meant is that anybody, if they hadn't gotten in the morning, they would be able to come in and get in line. It would be a start over at that point. So it basically meant if we wanted to be assured of getting our seats back in the courtroom, we walked out of the courtroom and did an instant U-turn and got right back into line. And that is what I did. So no lunch today, which is fine. It's fine. I'll live. But Judge Gull is really she's putting us on the Delphi diet here, guys. If I get a little gaunt by the end of this, you will know why. I don't actually mind the not eating nearly as much as I mind not being able to get something to drink, getting dehydrated. Is very uncomfortable. Don't like it at all, but it's just going to be part of what we have to endure in this particular situation. Because of course we can't bring any drinks into the courthouse. They do have drinking fountains, so that helps. I can gulp down some water, when I get a chance to get out there. But I tend to I'm not a particularly neurotic or anxious person. And so when I'm in a situation where there's kind of heightened stress, heightened awareness, and cortisol going on and stuff like that, it really affects me. It kills my appetite. I don't sleep well. So I don't suffer, I'm not hungry. But yeah, that's going to help me get through these no lunches. So I did get back in. This time I was number 23 in the back of the line. So once again, just scooted back in by the skin of my teeth, but I did make it back in after lunch. So the first witness after lunch was Kelsey Siebert, who is formerly Kelsey German. She is Libby's older sister. Described a very similar story as Becky. She herself was a couple years older than she was a junior in high school in 2017. So Libby was in 8th grade. She was a junior. She was 17. So she's 3 years older than Libby. She now has gone to school and gotten a bachelor's in psychology. She's now married, has a daughter, has another one on the way. So she described the school as being very small. Everybody knows everybody. She certainly knew Abby, knew that they were friends. Abby had gone on the vacation with them, spent a lot of time at her house, knew that Abby didn't have her own phone, and Libby always let Abby use her phone. She described Libby's personality as always the outgoing one and very brave. So she had gone out to the Monon High Bridge with Libby before. The very first time either of them had gone out there. It was within the past year. She says she was terrified and Libby was not scared at all. She described that she crawled across on her hands and knees. She was terrified, but she wasn't going to let Libby go across alone. So she did it. She had not been out to that trail before with Abby. So on February 13th, she had woken up late because they had the day off school. It came up that they were asking if she could drop them off at the trails, if they could get a ride back. It was not unusual for them to go there. It was a place that they felt safe. So she also confirmed Libby was wearing a tie-dyed shirt. She said she had given Abby one of her sweatshirts that was in the back of the car. She described it as a swim sweatshirt. I think she means it was for the swim team, for the school swim team, because it was brand new. It hadn't been worn. Abby was also wearing a gray zip-up jacket. And she also remembered Libby grabbing something out of her car. Kelsey was also on the swim team. And so she described that she would keep clothes, like changes of clothes and stuff in her car pretty regularly, like had a box in the back that had different pieces of clothing in it. So on the way, they were playing music. They were laughing. They were taking selfies. Libby posted one of the selfies, and it's not a photo I had seen before. It was admitted as an exhibit. It's a selfie in the car that Libby took. She's in the front seat. It's a very close up of her face, so like just a partial of her face, and then you see the back seat behind her and Libby sitting in the back seat. We got a map to kind of get us oriented, you know, show us where everything was. They're basically aerial, large, very big blown up aerial photographs up there. We had a little bit. We had the first that I've seen of Judge Gull getting on the state, chastising the state a little bit because they pulled out the big aerial photo and started to stick it up on this big easel. Now this is a big photo. When I say a big photo, I mean like no less than 6 feet long. You know, probably like 6 by 4, something like that. I mean, it's a big thing. And they stuck it up on the easel facing the jury. Well, it hasn't been admitted as an exhibit yet. So Judge Gull got on them. You need to take it down. You can't display it to the jury until it's been admitted as an exhibit. This is kind of evidence 101. But hadn't gone through that step. So got a little admonishment for that. So at some point they passed that camera at the Hoosier store, whatever it's called. And she oriented us through the different places on the photograph, where the trailhead is, where the trail went, where the bridge is, and so forth. So she was going to her boyfriend's house that day. She pulled into the entrance, which she described as very small at angles, kind of like a driveway. And there's only room for maybe about 2 cars to park there. So on this day, she pulled in, dropped them off, and then just continued on her way to her boyfriend's house. They went out for lunch downtown and then went back to his house, and then were leaving when she had to go to work. She described that Libby, the phone was always in Libby's hand. Libby's a typical kid, typical teenager, always has that phone in her hand, and that she was using it on the way to the trailhead. So after her boyfriend left for work, Grandma Becky had called after about 4 o'clock, and that's when she learned that Libby and Abby were missing. So she then went to town. I think I wrote this down wrong. I think I got the time wrong. Around, yeah, that can't be right. Around 1, I think it says 6:40, around 6:40. Anyway, at some point, she went out to the bridge. The family, everybody in the family was trying to call Libby's phone. She ended up out to the bridge. She and Cody walked out to the high bridge and went across. Nobody else in the family went across the bridge. They went down after they got to the end and turned to the left and went down that way to get to the driveway that goes underneath. So we had another photo that came in that was just a blow up of this particular area, the Monon High Bridge, the little bits of trail, and the road that runs underneath leading up to Brad Weber's house. So she oriented us around that a little bit. So they crossed the bridge, went down to the left, down to the driveway, and then took the driveway the opposite direction from Brad Weber's house, which is basically going downstream. And the reason why they went that way was because they thought Abby's house was kind of down in that direction. And so possibly, you know, maybe they had started walking back in that direction. But they didn't come across anybody, so they came back across the bridge. And at that point, it was starting to get dark. It was not dark yet, but it was just starting. They thought at this point maybe the girls were out in the woods. It really didn't occur to them that maybe something bad had happened. Kelsey said that she and Libby sometimes texted, but they usually would communicate by Snapchat. She was our Snapchat expert for today. She told us all about how Snapchat worked. We watched a video that a drone had made, basically following the Monon High Bridge trail from where you would get onto the main trail from the Mears entrance all the way out to the Monon High Bridge and across the High Bridge to the end. This video was taken recently. This was not something that they took at the time because the bridge has since been changed. The situation is different out there. She described some of those differences, but the main ones are that now the path is asphalted like it wasn't before, and as you approach the bridge, originally you just walked out on the original, not the tracks, not the rails. What are the other parts of the bridge? Losing my mind. The ties. You would walk out across, just like straight onto the ties. There's gaps in between them. There's no side rail. And it's terrifying. But they've modified it since then. So from the end of the trail out to about maybe a third of the way, 25% of the way, something, a short way out onto the bridge, they have taken out all of the old ties. They have replaced it with a sort of Trex-like decking. There's a rail around the sides now, and it also cuts off at the end. So basically, if you walk out onto the bridge, you can no longer walk all the way across completely unobstructed. You will run into this rail. There also used to be a barricade in front of the bridge. If you were coming down the trail, you would run into this barricade, but you would just go around it. It had a space to the side that you would go around it to get on the bridge. That barricade is no longer there. Just catching up on my notes here. She says if you have walked across the bridge, this bridge is long. It's very long. It's longer than it looks like when you just walk up to the end, because you see the creek, and when you get to the end, the current end of where it is now, you're still out over the water. You're still out pretty much over the middle of the creek. By the way, you can see the fish. It is clear. It is extremely clear, very clear water. But the bridge itself extends far beyond the creek. There's I don't know if it's a wetland area or if it's forested, like a low forest underneath, like a low area that the bridge continues to cross over. But it crosses over for a pretty significant length of time. Like if, say, the creek is, that wide, the rest of it is like, maybe that. So it's a very, very long bridge. She testified that if you're at the far end of the bridge, you can't see somebody way back at the beginning. So this is when she gave us a Snapchat education about how it works, that you can text back and forth, you can send pictures, but things disappear after a certain length of time. If you just send a picture, it disappears after 10 seconds or something like that, but you can post things to your stories and then it will last for 24 hours. So she saw that Libby had posted some Snapchat images to her stories. First was a picture of just the bridge, and then the second was a picture of Abby on the bridge. This is a famous picture. We've probably all seen it. I used it on one of my first thumbnails for my videos here. It looks like the same day, according to her, because it had the timestamps on it. She recognized the clothing that Abby was wearing. She said if somebody saves the image or screenshots it or something like that, that Snapchat will tell you, it will notify you that has taken place. I didn't know that. I don't use Snapchat. I never used it. I'm too old for Snapchat. So then she said she didn't otherwise hear from Libby that day. So then she met up at the police station. She went to the police station after finishing this search at the bridge. And After that, just went home, didn't go back that night, but they continued to try to text and call. The next day helped with the search, and her search group went back across the bridge and basically searched the same area that she had been in before. Only difference is they went down the right-hand side to get to the bridge, but they still searched under the bridge and on the, if you're facing the right-hand side of the driveway that leads away from Brad Weber's house back up towards the access road. So they were searching in that area and were just getting ready to head back when someone told us that they had found the girls, somebody who was closer to the creek. She didn't know who it was, but it was somebody who was young. Later, I think, learned it was there was a woman named Michael who was there that she had met at school before. She didn't know at that time, alive or dead, just, that they found her. So she went back across the bridge and just reiterated that she had no reason to be concerned about their safety when she had dropped them off at the trail that day. Mr. Baldwin's cross-examination was interrupted by somebody in the audience back in the back row on the far side. Stood up out of her seat with her hand up and was standing there for a few minutes. Judge Gohl eventually saw her, told her to sit down. The woman said, "The microphone is not pointed towards the witness." And Judge Gohl said, "You need to sit down, ma'am." Said this twice. She wasn't having it, didn't want to hear from the woman in the audience. It doesn't matter typically if the microphone is not pointed towards the witness. I think the person in the audience might have thought that these microphones would amplify, and because we did have difficulty hearing, that was part of the problem, but it's not. These are not amplifying microphones. They're just for the audio recording system, for the audio recordings that we're not getting to hear. The court records that's being produced as the record of this process that we're not getting to hear. But nothing else, like she didn't get kicked out of the courtroom or anything like that. She just, sat back down and the day continued. She described Hoosier Harvest, that's what it's called. So she described where the Hoosier Harvest was on the map, and so indicated she would have passed that camera after she dropped Abby and Libby off. It was right there on her way going into town. She also reiterated Libby was outspoken. She would absolutely stand up to others. She was not afraid to raise her voice. She had a good, strong voice. It was around 4 p.m. that she found out that the girls were missing, and the search was after that. That she connected with her Uncle Cody, and the reason they went directly to the bridge was because of that Snapchat photo. So they knew that the girls had been there, and that was the last information they had about their locations. So she described this bridge as having such big gaps in it that there were spots people could fall through, that the ties were rotting and stuff like that. And so that's why the first time she went across, she crawled on her hands and knees. I would not have made it. She said, no way would you run across. You would not run across that bridge. It would be dangerous. So the picture of Abby, we spent some time looking at that. She's seen it, of course, many times. So the photo is taken where Abby is in front of Libby going across the bridge. So they've left the trail. They're going across the bridge towards the end. Libby is in front. She turns around to take the picture of Abby facing back towards the beginning of the bridge. And she can tell that they were not very far across because you can still see the water in the creek. Remember, I mentioned the creek is like this, and then the rest of it is like that. So Abby is still in sight, or Libby is still in sight of the water. So they had not made it very far across the bridge. She estimated it was about 25% away of across the bridge, but the state objected to that as speculation, and that was sustained. So that's stricken. They don't get to hear that specific bit. The photo, the Abby photo, that she took of Libby, that Libby took of Abby. Gosh, I'm sorry. It's been late in the day, and I'm starting to get my wires crossed a little bit between not a lot of sleep and not a lot of food and being late and everything. Uh, the photo that Libby took of Abby, the defense introduced as an exhibit. They did something interesting, which is that they made a whole bunch of copies of it to distribute to the jury so that they could have their own copies. I say this is unusual just because courts can be real strict about the evidence and about how what the jury is supposed to be looking at and making their decision on is the evidence. And so copies are not the exhibit. They're not the evidence. It makes a lot of sense from a logistical standpoint for juries to just have their own copies. I had a trial once where we had all these exhibits. I had specifically this presentation that my client had put together. This was a case where she was a homeowner. She had hired a contractor to do a remodel on her house. She had paid him about $250,000, and he had not even finished the demo. It was really terrible. So what she had done is compiled a presentation of the checks showing the different amounts that she had paid him at the different points in time, and then photographs of the condition of the house corresponding to those times to basically show, this is how much work had been done when I paid him this amount. This is how much work had been done when I paid him this amount. And so I had made copies of this presentation to be able to give to the jury. Well, the opponent objected, and the judge sustained it. I wasn't allowed to hand out the copies. Well, it turned out that sometimes you need to be careful what you wish for, because what I did instead then is I just hand published every single one of those photographs and those checks to that jury one by one. Waited patiently while they passed it down, and everybody took a look at it with absolute horror and shock at what they were seeing. And it took so long, it got us to the end of the day. That's how the day concluded. Frankly, worked out great for me to not have to do the copies. My client did win that case, by the way. This case, they're going to be allowed to apparently have copies of some of these exhibits. Later on, Ms. Diener kind of popped up to say, can we make copies of our exhibits for the jury too? And Judge Gold's like, yes, of course you can. So they actually went during the afternoon break and made copies of their first exhibit, the selfie photo that was taken in the car. They went and made copies of all that for the jury too, so they wouldn't be left out. So you can see on the photo, there's nobody on the bridge behind Abby. She would see people from school out there all the time. This was a common place for kids to go. She saw two people that she knew from school out there when she had returned to search with Cody. I didn't catch their names. They were too low, but she did give their names. She said it was not uncommon for people to be on that bridge at any point in the afternoon. She said that she confirmed that the swim shirt Abby had taken out of her car was new. It had not been worn, but she said that they probably would have washed it. So what they're getting at is this is a possible explanation for the hair and how the hair got there, where it came from. Because if it's one of Libby's relatives, it could be Kelsey. It could be somebody else in the home, one of the other females in the home, and it could have gotten into the sweatshirt in the wash and then transferred from the sweatshirt into Abby's hand. So we won't know until, of course, the DNA results come back, what that means. But that at this point is looking like a possible, if not a probable, explanation for the source of that hair. So a little bit anticlimactic after that preview that Mr. Baldwin gave us in the mini opening. She also confirmed that she gave her DNA 2 days ago, and it was not the first time that she had provided it. So we don't know if police lost it, didn't submit it, what happened to the first round of DNA, but we know that they did not test the hair until now. Yikes. The last witness from the family, from the German family, was Derek German. This is Libby's father. He was he spoke louder and a little bit more openly than the two witnesses before had. Becky, I said she's very quiet. She was clearly grieving. Kelsey was also quiet, soft spoken. She didn't appear as emotionally affected by the process as Becky did. Obviously didn't love it. But just different demeanor, more engaged, more responsive. Becky, like I said, was fairly flat and kind of short with her answers, very quiet. Derek German is more of a, he's a little bit louder, a little bit fills in some of the details, volunteered some stuff, things like that. So he is local, grew up there around Delphi. They lived just outside of town. At the time, he wasn't working full time. He was working kind of odd jobs, including helping his mom with the appraisal business, where he would take the pictures for her. Did a lot of helping run Libby around. He said she always forgot something at one of her practices or something like that. So she's always forgot something. That got a laugh from the courtroom. She was in lots of activities, and so he was constantly running to bring her swimsuit, bring her food. She needs a snack, before her practice, stuff like that. So he would be going to the school a lot. So he did not have Snapchat, but they would text. He said he would try to call because he doesn't like texting, but Libby wouldn't answer. So I think they would just end up texting. Obviously familiar with Abby. He had picked her up the night before to spend the night at their house. The day before, he had picked Libby up. Libby had slept over at another friend's the night before on Saturday night. So he went and picked her up on Sunday. They picked up Abby and had the sleepover. The next morning, he made banana pancakes. He was doing something about painting a desk in the garage, and then he left to go take the pictures for his mother. And that was maybe 20 minutes after 1 or so. He had 18 houses to photograph, so it was going to take a while. When he was about halfway there, he got a phone call asking Libby if he would be able to pick her up from the high bridge. So he explained this was going to be a while, and it's going to be a couple hours and you're going to have to wait. But he did it. He took the photos and then went straight back to the Delphi area. On the way into the trails, he did not pass the camera at Hoosier Harvest. He came from the opposite way. So when he arrived, he had not been out on the trails or the bridge before. He's not a hiker, I guess, didn't spend time out there. So he tried calling first when he was just a couple of minutes away. He didn't get an answer. So when he gets to the entrance, he calls again, still not getting an answer. Saw that there were other cars parked there. Siren going by. I don't know if you could hear that. So he started walking around the trail to see if he would find them. He ran into somebody at a junction point where multiple trails meet. So I mentioned when I walk the trail, you come in from the Freedom Bridge. This other trail comes in perpendicular, is the Mears Access Trail. There's another trail that also goes perpendicular the other direction, that goes down to Deer Creek. I actually walked that trail while I was out there too. It's kind of a small hill, like not steep at all, just a gradual descent down that takes you down to the creek, downstream from where the bridge is. You can't really hike around much at the bottom if you're not going to get in the water. If you get your feet wet, you can go as far as you want, really. But if you don't want to get your feet wet, you kind of run out of room at the corner and where there's a curve in the creek, and you can't see the bridge from that corner. So the bridge is a little bit further down. So he met somebody at the intersection of all of these trails. Later, didn't know the man, but later learned his name was David McCain. He asked the man if he had seen two teenage girls. The man said no. So because the man had been coming from the direction of the Monon High Bridge, he went the opposite direction towards the Freedom Bridge. This was about 3:11. He had looked at the phone. He looked at his phone data to get the time. So he walked down towards the water on the Deer Creek Trail. He didn't see anybody. He walked back towards the Freedom Bridge, didn't see anybody. He's continuing to try to call. So he went back to his car and called his mom first. She hadn't heard anything. He called Libby again, gets no answer. Called the mom again, goes back on the trail. He's yelling the girls' names in all directions. He's not getting any kind of response. Goes back to his car, waits about 15 minutes, nothing. So he goes back out and now he walks down to the high bridge. While he was sitting in the car, a couple of kids came back from that direction. Or no, I'm sorry, a couple of kids arrived and went out towards the high bridge. So I think he followed the kids out there. He did not cross the bridge. He saw the kids sitting on what he described as a little deck on the side of the bridge. There's a series of landings in different spots as you go across the bridge, where basically you have the ties and then there will be a little section off to the side where you can walk and be off of the main trestle. It's about 4 feet by 6 feet. He described it, so about as big as the photographs that the state had in court to get us oriented. It was a boy and a girl. So that's all we knew about them. Kelsey and Cody then arrived. They said they were going to go across the bridge, so he went back to the car. Kelsey had parked there, so he got in her car and was trying to figure out what to do next. Then Mike and Betty came. They had to park outside because by this point that you can't fit any more cars in the parking lot, so they had parked across the street. Becky is making these phone calls to AT&T. He went back out on the trail, and at this point, cops and people are starting to show up before he made it back out to the bridge. It's still light out when they went to the police station at this point. So his mom and brother Cody went downtown to look around after the station, to look at some of the parts of the trail. The trail system connects to all sorts of different sections. Some of them go through the downtown area. So they went to check some of those other sections of the trail. Of course, didn't find anything. Again, walked back out to the high bridge. It's dark now. And when he got to the bridge, not crossing, but on the near side, there's a wooded area off to the left. So he had his flashlight and he was searching over in that wooded area. Did not find anything. He was by himself. He wasn't searching in a group at this point in time. He described that area as extremely steep down to the water. And I can confirm, if you're coming up to the bridge on this side, there is no path down. It is a cliff. Like it's, I don't know if it's limestone or, what the geology is, but it's a cliff. Like it's an exposed bluff. You can see the layers of sediment and stuff. You're not climbing down that. It's extremely steep. So he didn't go all the way down to the water. He stayed up on the high ground. He followed this wooded area down to where it ends in a ravine. The ravine runs south from a cemetery that is up in this area. So he basically covered a large section that is kind of west of and beneath the cemetery over to the ravine. The ravine he described as being too steep to be able to cross. By this point, it was midnight. It was pitch black. He could see maybe 10 feet in front of him. Not very good visibility. But you could see all the way onto the other side. It has a high bank. And so they were continuing to search until about 12. He could see flashlights on the other side of the water under the high bridge. But he saw no flashlights on the far side of the ravine, the east side of the ravine. He stayed on the west side. He saw nobody on the east side, and that's important because that we're going to find out is the area where Abby and Libby were found. He went back to his car, went home. Next morning, went out to do the search, got in the group. His was the same area he had searched the night before, so that same forested area. They parked at the CPS building and walked through the Mears lot and basically searched the forest, alongside the trail all the way down until it met up with the bridge. His daughter was with them. Went all the way to the ravine. He ran into his Aunt Melissa, Becky's sister Melissa. She was not in his group. He wasn't sure if she was in a group at all, but she was out there searching at the end of the ravine. She had come up behind them and said they needed to go back to the entrance. So by the time he got back, there were cars there. He could tell something was up. He could hear his mom screaming. Melissa came running off the trail screaming. He saw the coroner's van. He saw about 12 cop cars go by. He said his dad took Kelsey back and called her and told her what had happened. That was his direct. Mr. Baldwin again did the cross. He said he didn't know who was searching in what areas before then. Reiterated kind of the orientation of the trails and where exactly he ran into Dave McCain. His timeline is that 3:11 is when he made the first call to Libby. So this would have been when he was on the way, according to his initial testimony. He called, when he was on the way there, a couple minutes out. And then, so he estimated it was about 3:25 when he was coming from the high bridge, and he saw the couple down there taking pictures. He didn't hear anything, no, screams or anything like that. Saw lots of lights between 10 and midnight. They were on the surface road, facing back towards the creek. It was bright enough to illuminate the opposite side of the creek. There were tons of people out looking for girls. In some flat areas during various parts of the night. This area, however, he described it was not familiar to him because he had not spent time out there as a kid. So this was not a place that he knew like the back of his hand or anything like that. Had our afternoon break after Derek German testified. We had a few sidebars over the course of the afternoon, and Judge Gull has a white noise machine in this courtroom. I've never been in a courtroom that has a white noise machine, so that was a new experience for me. It is fairly loud. It really does block out pretty much anything that's happening. So what they're doing, they have the TV screen and they have another like screen kind of over in the corner. Like here's the bench. Here's where Judge Gull is sitting. Her court reporter is sitting right next to her, and then here's the corner with the screen and the TV. So they're going like behind the screen to do their sidebars and have the white noise on. So we don't get to watch the sidebars either if they go behind that screen. Just an interesting piece of information. Next witness was Anna Williams. This is Abigail's mother, Abby's mother. So they had grown up in Michigan. They weren't local, but moved there in about 2006. So Abby was quite young and had lived most of her life there, attended the Delphi schools. The school was across the street from where Anna worked that time at a sounds like a hospital, where she worked in the kitchen. She also would bartend part-time at a restaurant in a nearby town. So she did not always have a regular schedule, but she did work a lot of evenings and afternoons because of that bartending and waitressing type of job. She described Abby as very kind, helpful, funny, smart, and reserved, quiet. Said she did fair at school and liked to read. She had her subjects that she liked and did well at, and others that she was not so fond of. Her group of friends was pretty small, and it was mostly a lot of the same kids that were all in the same activities, so they would get to know each other. Anna, because of her work, wasn't nearly as acquainted with Abby's friend group. Didn't have the friends over to her house to sleep over and stuff like that nearly as often because she wasn't available to supervise. Confirmed Abby didn't have a phone. They had figured that once she got into high school, it was going to be necessary, but for the time being, it had worked for her to not have one. She described Abby as kind of shy, said that she would push for her to remind her to maintain eye contact when she was talking with people, even when she was about 7 or 8 years old. She wouldn't go out of her way to talk to people that she didn't know, but if she did know you, she would be very comfortable. She said she loved roller coasters and heights didn't really bother her that much. They had been out to the bridge before, but had never gone across, and Anna did not know that she had any interest in going across, and didn't know that she had, and said she would not have given permission if she had been asked. It's a scary bridge, guys. Can't say that enough times. This bridge is scary. So she knew who Becky Patty was, but they were not like super close, chit-chatty or anything like that. Just had communicated with each other for the kids. It sounded like she knew Kelsey a little bit better. Abby had gone to Florida with them for the spring break. Abby had no siblings, and she was close with her mother. On February the 13th, there was no school. She had been spending the night at Libby's house. The night before that, she had been with her grandfather. I couldn't quite hear a lot of the details of what they were talking about. They stayed at a hotel somewhere, but I couldn't pick that up. It was just too soft in the courtroom. She described that she picked the girls up and took them back to her house, and Abby packed her things to then spend the night at Libby's house, and that she took them back. So a little bit of a dispute between her and Derek about who took the girls to Libby's house for the sleepover. Not a critical detail, but just a thing to know. The funny thing about how memory works, nobody here is on the stand trying to lie. Everybody is being sincere, trying to tell their best story, and they remember things differently. That's just how it is. So she was working a normal shift, and during the break that day, the 13th, Abby called her to ask if she could stay into the afternoon. So Mom said, that's okay, but you got to know I work until about 8 tonight, so I'm either going to have to pick you up before work or pick you up after. Becky agreed that she could stay that long if she wanted to stay till after work, so they agreed that Mom would pick her up after. She didn't know Monday night that they were going out to the High Bridge Trail. So she had got a call at work around 5:30-ish that from Becky that the girls were out at the trail. They didn't come back. Becky had called multiple times that she missed. She, was working. So also she did not have Becky's name attached to the number in her phone. She didn't have Becky in her phone as a contact. So the number came up repeatedly. She didn't know who it was, and it wasn't until she picked up the phone and talked to her that she realized it was Becky, and that connected with the previous calls that she'd received. So she explained to the people on shift what had happened. Didn't think it was going to be any big deal, just that she would need to go and figure it out, and would possibly be back later to finish the shift. No thought of anything horrific had happening. She did describe that there was one previous incident where the girls had gone missing, and it was when they were at high school. They had been watching a swim meet She was supposed to get them. Neither of them was answering their phones. She couldn't find them, and eventually they just walked out, and were able to connect. But it really wasn't their habit that she wouldn't be able to reach them. She had no concerns about the girls' safety, leaving them out there. That was all she testified to. It doesn't sound like she took part in the search or anything like that. So Mr. Baldwin's cross-examination just went to Abby's voice. He's going to the volume of their voices. He's clearly laying this foundation to suggest to the jury if they had spoken or screamed, they would have been inclined to do that. They had the voices where they could have been heard had they been inclined to do that. She said with her friends and family, her voice would be normal volume. With strangers, it might be less. That was it. So at this point, it was 4:15, 4:20, and the state announces they have no other witnesses scheduled for today. Judge Gold was not pleased. She's pressing her lips together. She has already made comments to the parties about scheduling and how she wants witnesses to be ready, for them to be scheduled so that they're making good use of the jury's time, that they can go late. So this was not an auspicious start. We had an inauspicious start with the opening statement, and now the final witness is finished early and they didn't have anybody else lined up. Well, they did scramble, and Mr. McLellan said, actually, we do have somebody else we can call. There was a deputy witness. Guess he was nearby, maybe in the courthouse or something like that. So they were able to call him. This was Deputy Mitchell Catron, I believe is the name. And the reason why I can't be sure, one thing that Stacy Diener did that I love, I really appreciate when people do this, she had the witnesses spell their names for the court reporter when they got on the stand. Mr. McLellan did not ask Deputy Catron to spell his name. So I'm guessing, going by what it sounded like in this not very good sounding courtroom, but I think that's what it was. It was Mitchell Catron. So he was on duty that night on February the 13th when the call came in about the missing girls. It came in about 5:15 that he got a call from dispatch that the gentleman was on the phone reporting a couple kids weren't showing up where they were supposed to be, and it was Mr. Patty. So the call was transferred to him. He spoke with Mr. Patty, with Mike. He reported they had looked around a little bit and they were getting concerned. He gave their names as Abby and Libby. Dispatch announced that he was going out, so he drove out to this access road that leads down to the private drive that we've been talking about that goes underneath the Monon High Bridge. There's houses only at the far ends of this driveway, nothing in the middle. And so Brian Weber lives at the far end. He gave us some more orientation just in terms of like the direction that the river flows, and this is where we established that the bridge is significantly longer than the creek is wide. He stopped right underneath the bridge on the driveway first, got out, looked around. He didn't go very far. He was always inside of his car, and it's a very woody area down there. He didn't see anything. He didn't yell. He didn't put on his lights or sirens or anything like that. And he spent about 5 to 7 minutes, he estimated, looking in that area. He then continued up the driveway to Mr. Weber's house. He didn't know who lived there. He just knocked on the door, contacted the man, asked if he could look, or explained what was happening, asked if he could look around on the property. The man said okay. The man was not disheveled or sweaty or bloody or nervous or anything like that. He said he was asked what was the man's demeanor when he answered the door, and the officer was like, well, pretty much like anyone's demeanor when somebody knocks on your door, you know. So it sounds like he maybe wasn't the most welcoming, but he wasn't antagonistic or anything like that. He walked away from the creek, from Mr. Weber's house. There's a field behind the house. And so he walked basically along the field line down towards where there is a barn situated at the end of that field. He did not go inside the barn. He didn't see anything. There was nothing that stuck out to him. And so he went back to the driveway, headed back out. He was keeping his eyes open as he headed out. At this point, his shift is ending. The night shift is coming on. And it was getting dark. So he left at that point and went home. He had not gotten any further updates from the dispatch about the girl's location. So Ms. Auger did this cross-examination for the defense, and she tied him down a little bit on some of the details of the timeline, so that it was 5:15 when the calls came in, and she worked through how long would it have taken him to get there, probably 5 to 7 minutes. Okay, so that's 5:22 to about 5:25 that he would have arrived. Asked why he chose to go the direction towards the Weber house. And he said that he had been out there before for a criminal mischief complaint about a chicken coop, like maybe somebody stole a chicken or something. Criminal mischief is usually like vandalism or something, but that's all he told us as details. He had been out there, so he knew that the drive went under the bridge. At that time, it was getting dark, but it was still light enough to see. She walked him through the timeline according to his CAD report. She confirmed that the CAD report gets information that he calls into dispatch, and so then they note that down, and it's a computer assisted system, and so the computer generates the time when notes are entered. So it was at 5:47 when he was at the High Bridge, according to the CAD report. He searched for about 5 to 7 minutes around there. He did not go down the hill, and he did not see or hear anyone at that point in time. Down the hill, it sounds like the hill goes further past where this drive is. Like there's a bank on the side of the drive that goes down to where the water is. So he didn't go down there. Didn't see or hear anyone. Continued down to the Weber house. It's not far, maybe an eighth to a quarter of a mile. He said you can see in the direction of Deer Creek, but you can't see the water because of how the terrain is. So there's the sharp drop down to Deer Creek over on the north side, the opposite side from where he is, the side where Abby and Libby's bodies were found. But you could see across because there's no leaves on the tree. So from his perspective, his vantage point, he can look out and see the area near the water on the opposite side. He said his conversation with Mr. Weber was maybe 1 minute tops, not very long. There is a second outbuilding besides the barn on the property. He didn't go into either of the outbuildings. At about 6:15, he advised the dispatch that he would check along the trails on private property. He was referring to over on the other side of the Monon High Bridge where the driveway continued. There are some trails over in that area that he indicated. So that's what he was talking about. Said he didn't spend a lot of time doing his search out at the Webers, maybe 5 to 10 minutes, and he did not stop at the bridge again on the way out. He said he's never been on top of the High Bridge. He understands that when you come across the trail, it doesn't really continue. It kind of continues like you could go straight forward, but then it just kind of diminishes and vanishes. It goes away. You run out of trail, and there's nothing else designated there. He did know that there was a search, extensive search that evening, but didn't know the magnitude of it. After the February 13th call, at some point, he was pulled off of his particular duty. He was assigned to be on the tip line. So he would receive, he would get tips that had been phoned in previously and follow up on them. And he did it for maybe about a year after the incident. During that time, he did not investigate any tips concerning Richard Allen, and he never heard of any tips concerning Richard Allen. Ms. OJ then indicated she had some questions that would be outside the scope of the direct examination, and asked if she should do it now or if they should recall him. So then they had a sidebar. Mr. McClelland and Ms. OJ approached, and they had a chit chat back in that corner behind the screen. And when they came back, Mr. McClelland took up the questioning. So that means he's going to be recalled in the defense case if they want to bring him back. They did not agree to let her go beyond the scope of direct examination. This is one of those technicalities that it's really it's honestly like a super technicality. Don't always get why they do that, especially since Judge Gull has shown herself to be concerned about, logistics and time frame and being efficient about the process. It's way more efficient to ask the guy all your questions now than it is to call him back a second time. So I am left to assume that Mr. McClelland objected, and because Mr. McClelland objected, she agreed to do it the way he wanted to do. He had a short redirect that just confirmed that officer did not go down to the creek at any point in time. He didn't look across the creek. He didn't get out of his car. And the jury, we got our first jury question during this witness. So the jury actually had two questions. Both were allowed to be asked. The questions were, is it common for people walking the trail to stop at the high bridge and turn around? He did not know the answer to that question. I don't know either. I would think it is, because I would think a lot of people don't want to go across that bridge. And then they asked if there was a trail to be able to go down to the creek instead of going across the high bridge. This is that very steep, like limestoney kind of area I was mentioning. And the answer to that is no, there is no trail. That was it for our witnesses. We then had two offers of proof from the defense. So first, there was a deposition of Hannah Williams, and this was explained by Mr. Baldwin to relate to the third-party suspect issue. They have already they had the evidentiary hearing on. Judge Gold granted their motion to be able to use that evidentiary hearing as their offer of proof. They are now adding to that with this deposition of Hannah Williams. The state did not object to that, so that was allowed. There was also just from the deputy. The deputy was going to be the offer of proof. They clarified that they will deal with that in their case in chief, not deal with it at this point in time during the case. So apparently not really more examination for the deputy, Katrin, but just to establish an offer of proof from him. Judge Gold was irritated about this deposition. She was looking at the deposition, looking at the schedule, the timelines and stuff. The hearing took place in late July into August. This deposition took place at the end of August. And so Mr. Baldwin was explaining that. But the judge was still like, you couldn't have offered this earlier, I think meaning because the deposition was taken on August 30th. And Mr. Baldwin just said no. And that was that. It does take a while to get deposition transcripts. It's not like you can just snap your hands and they show up. You know, you take the deposition, you have to order it. It takes them however long it takes them to be able to produce it. There's a review process often. I'd have to look at the process for Indiana, because I haven't checked that. But often with the deposition, it goes to the witness to be able to review it and just make sure it's accurate, doesn't misstate anything that they said, or, have discrepancies like that. And so they then can sign off on the deposition when it's verified. I don't know if they have a process like that, but if they do, then that's, presumably going to take some time too. So yeah, not super surprising that 45 days after the deposition roughly is when they're offering it. But yes, Judge Gohl was not particularly pleased with that. That was the conclusion of the evidence for today. Now remember, because Judge Gohl reminded us that the media demanded access to the exhibits at the end of every day. Demanded. I put that in quotes because that is the word she used. The media demanded it. Well, they should demand more when it comes to public access. But they did indeed demand that. So she confirmed that, that was going to happen. And the way it worked was they just put the exhibits on a table that was over to the side of the courtroom, near, like, in front of where the jury would have been sitting in the box. And then the media was invited to go into the well and inspect the exhibits. I was waiting there right by the well, and I was kind of waiting to see what was going to happen. I, of course, am not media, and I didn't know what the process was going to be to look at them, but I have every right to look at them as a member of the public. And so I was the first person into the well to go in and take a look at them. I walked right past Judge Gohl, no badge or anything like that. And, she said nothing, didn't look at me, whatever. So I looked at the exhibits. That's how I saw the selfie that was taken in the car. Because the way the screen is oriented in the courtroom, the TV screen, one side of the courtroom really can't see it. That's why I moved sides in the afternoon. It's a little bit of a trade-off, because the side where you can't see the screen, the witness is facing you so you could hear the testimony better. On the far side, you can see the screen, you can't hear the witness. I will give a lot of kudos to Mr. McClelland. He has a very good, loud voice for the courtroom. I didn't have any trouble hearing Mr. McClelland. And in terms of his style, his questioning style, he's definitely better at it than Ms. Diener. He knows how to rapid fire the "where did you go?" the open-ended, get the guy where he needs to be. Where did you go? What did you do? What did you do after that? Did you see, how long did you talk? Things along those lines. So he is a good questioner. By and large, a skilled lawyer. I don't hold the coke here against him. It's just an observation. So I did go see the exhibits. I learned after the fact that apparently the media was not happy, not pleased that some other folks who are not media had tried to go in to look at them as well, and were like, the order only says media. You need to clear it with the judge. The law doesn't say only the media gets to look at the exhibits. I didn't like the gatekeeping whatsoever. I didn't like the gatekeeping. What on earth? You're supposed to be in there for our benefit. You, the media, are getting this special treatment because you're supposed to be the representative of the public. But we, the public, are here in the courtroom. We can see for ourselves. So anyway, they didn't say any of that to me or try any of that to me. And, I recommend they don't, because I'm not going to care. It's none of your business. You want to take it up with the judge, you take it up with the judge. I'll be happy to tell the judge that I'm sure she knows the law about public access, and I'm not causing any additional difficulty by being here looking at the exhibits at the same time as everybody else. So I'm not particularly concerned about it, and I intend to continue to do that. That was the day. We wrapped up right about 5 o'clock, maybe a little bit before. I think by the time we had looked at the exhibits and made our way out, it was 5 o'clock or a little bit after. Lots of media outside, lots of media tents, lights. JLR is there with his cell phone, videoing everybody and everything. I did not stop to chat. So, yeah, it's the circus environment, so to speak, which just really, it really is very unfortunate because it's so unnecessary. This was my theme with pretty much everybody that I talked to today was just how we should have these audios. We should have the audio recordings. The law requires them to be disclosed. If the public had them and could listen to them, we could do that from the comfort of our own homes. And we wouldn't have to be showing up at 3 o'clock in the morning outside the courthouse to sleep on the concrete so that we could know what's going on. And there really seems to be pretty universal consensus about that. It's one of the things I found was a real common ground. No matter what side of the case where you were on, are you leaning towards Mr. Allen's guilt? Are you leaning towards Mr. Allen's innocence? Have you been, at loggerheads with other people over the course of this case and social media and conflict and all that stuff? Doesn't everybody agrees? We should have those audios and it would just make everything so much better. Really, really unfortunate. So, yeah, considering pushing that issue, somebody really needs to. The media should do it. They should. It's their job. But they really don't seem to be inclined to do anything particularly confrontational with Judge Gohl. They'll ask, but pretty much take her answer for a given. This whole issue with the exhibits is really the first pushback I think I've seen, maybe ever. Maybe. What had happened is they had requested to view the exhibits, and she had said no, just flat out said no. So they filed a motion to reconsider. And at that point, she modified her decision and set this rule: 15 minutes at the end of the day, they can be watched. The media, from my perspective, did not cover itself in glory today between the shenanigans with the folks who can't follow the rules and just an obvious. To me, this is an obvious thing. Like, if you've ever been to a trial, surely you know that you would respect the privacy of the jurors. So perhaps these are ignoramuses who have, never set foot in a courtroom and know little about American civics. It's entirely possible. But it's also possible that they did know, and were just, trying to do whatever they could get away with. And that's just an unfortunate pattern that we've seen in so many cases, certainly over in Idaho, similar thing. Couldn't follow the rules, got the cameras yanked out of the courtroom. Fortunately, the judge, allowed us to have that backup with the court's video conferencing system. Between that, the playing the gatekeeping with the exhibits, and just the overall, lack of courage when it comes to fulfilling their role to get the information out there for the public. Yeah, it wasn't necessarily a glory day for our fine folks over in the traditional media. That was it, guys. It was a long one. I'm going to go ahead and take up some of your questions now because it is getting late. And I have an early morning tomorrow. Like I mentioned, I'm getting on an airplane. I'm going to fly back, go to a boxing match, get some sleep, fly back on Sunday, get back about midnight, get back in line at Delphi. So I'm going to do what I can to get as much rest as possible this evening. It will not be a ton. I think I got to be on the road to Indy at like 4. So we're going to test my endurance on this trip. We really are. We really are. So first off, we have Debbie W. became a YouTube member. Thank you so much for joining, Debbie. We're glad to have you. Just the tips. I'm not going to read that name. Sorry. This trial is finnibus. Yeah. Yes, it is. Indeed, it is. 40 Doherty spent all day in Florida with EDB, now in Indiana with you. Well, welcome, welcome. I'm sure Florida has been quite a bit of drama itself, and Emily would be a great person to watch that with. I can only imagine. She's going to have some reactions to what I fully expect to see happen in that trial. That trial, by the way, is Sarah Boone. Shy Gal 8 gifted 5 Andrea Burkhart memberships. Thank you so much, Shy Gal. Glad to have you. DK, when the judge said the jurors could talk about the evidence only at the courthouse, or can they continue talking at the hotel? Seems like a slippery slope either way if not monitored. Thank you for your time covering this. Yeah, it doesn't specify. It says they can talk about the evidence as long as they are all together and as long as they don't reach an opinion. Don't come to a judgment at that point. So doesn't seem to preclude them from being able to chit chat back in the hotel, you know, hanging out in the common room, watching the TV or something like that. If they're all there, yeah. I mean, it sounds like they can talk about it. They can talk about it all on the bus. No restrictions like that put on it. I agree. It does trouble me a little bit, because how do you not start to form your opinions when you're talking about this stuff? I mean, I might in my own mind think, okay, I'm watching this in trial and my reaction is, this thing is kind of weird. Well, you test that opinion and you kind of validate it or invalidate it by bouncing it off the other people. That's what the whole deliberation process is about. And so if you're able to have those discussions ahead of time, it's just hard for me to imagine how you're not coming to conclusions and forming judgments. Now, maybe they just mean really technically, as long as you don't decide definitively guilty or innocent, but that is also, it's a slippery slope. It's a slippery slope, because once you start processing the evidence and what you think about it, that's going to lead you down the inevitable path to what you think about guilt or innocence. So it is quite a strange process from my perspective. Doesn't sound like it would be monitored. That's another weird part about it too, because the jury is being monitored by bailiffs 24/7. I saw that they are going to be able to watch TV at their hotel. They have a TV. They'll be able to watch sports and they'll be able to watch movies, and they will be supervised by the bailiff at all times while they're doing that. During deliberations, they're on their own. So the deliberation by design is completely private. It's confidential. Nobody's listening in. But if they're having these chit chats about the evidence, yeah, it seems like they're having those in front of the bailiff. So that's kind of a weird little twist too. The bailiff is going to start to know what their thought process is if they're having these conversations. I am not comfortable with that at all. So this is, to my mind, a very strange process. Don't get it. Don't particularly like it. Anon, thank you. Well, thank you, Anon. Thanks for being with us here tonight. Shy Gal 8. Wow, the more I hear, the more I think he will be needing a damn good appellate attorney at Andrea Burkhart. Well, he's hopefully got Kara Weinecke still in the corner. She did a fantastic job there with the writ processes that they had to take up to get Baldwin and Rozzi reinstated. Yeah, that whole thing was quite a coup. I've said over and over again, my lord, getting a writ of mandamus against a judge on a pending criminal case, this is the holy grail of accomplishments in the Court of Appeals. Like, it does not happen. This never happens. They made it happen. So hopefully he's going to have folks like that in his corner if they're in a situation where this needs to go up on appeal. But I agree. The more of these decisions keep coming down, just the more concerned I am. The third party culprit is certain to be appealed. It's certain to be appealed. There's just no question about it. And from what I know of that third party culprit evidence, it's a good issue. These evidentiary issues are not always good issues, but this is a good one, because even by the standard, I don't know how you say, even if we say There's a higher standard than relevance to admit third-party culprit evidence, which some states do. My state does. Washington has a higher standard than relevance. There's an argument that it's constitutionally problematic to have a higher standard than relevance because you're penalizing the defense with a higher standard than you are the state, and the defense, of course, has a constitutional right to present a defense. It's fundamental to due process. But even if they have a higher standard than relevance, this requiring some proof of a direct connection and stuff like that, they have a confession. They have incriminating statements. How is that not a direct connection? I don't know how we get past that. So to me, this is a good issue. Could still be harmless error. Things could always be harmless error. The test for that, though, is usually they look at the trial as a whole and say, well, is the evidence of guilt overwhelming either way? I don't think it is in this case. I mean, not so far. Not so far. Still gonna wait and see on this details that Richard Allen supposedly knew in his confessions that only the killers would know. If that's the case, and these are significant details, that is significant evidence of guilt, if that is the case. If it's not, if it's innocuous stuff, if it's like the 10th thing that he said after throwing out 9 wrong things, folks guided him along to the right answer, that's not compelling. That is a false confession. So we'll see how that plays out at the end of the day. But I agree. I'm concerned about this case from an appellate standpoint. I'm concerned about these rulings. Indy Cindy never looked at Abby's house. Yeah, they didn't. They didn't go to Abby's house. Becky stopped at Abby's house that evening and spoke with the grandfather. The grandfather told her that Anna, Abby's mother, was at work, so then she went to work. So they did have that one point of contact at Abby's house, and they had the couple little parts of the search where they went in the direction of Abby's house. But it's true, nobody said, like, we checked the route all the way to Abby's house or anything like that. They didn't even say, like, they had checked the fields in the area near Libby's house, like if they had started walking back and, you know, maybe didn't make it or something like that. They didn't describe doing anything similar like that to Abby's house, which is a little curious. Kathy Trout, thank you for covering this trial. It is hard for me to watch trials involving children. Hugs. Yeah, it's hard. These are not fun cases at all. Not fun cases at all. Arla 7247, Body of Proof stars Dana Delaney. That's the redheaded surgeon. Okay, I'm going to write this down because I'm going to have to check that out now. Never heard of Body of Proof. Dana Delaney. I'll check it out. Have something to watch on the plane, maybe. Clinton Hall. Clinton, my man. Thank you so much for that seat cushion. It was awesome. It was great meeting you and Lawyer Lee today. So thankful for the great company in the miserable cold this morning. How many pages did you get through today? Today I got through, I have 1 page left in my full legal pad. I got through almost an entire legal pad today. I did, however, I'm still on the same pen that I started yesterday. So I think my first pens were probably old pens that were already close to done, or else this is like some magic pen that's never going to run out, because it filled this entire legal pad and about half a legal pad yesterday. So we're doing good on the pens so far. But yep, everything but 1 page in that legal pad for today. Yeah, Clinton was sitting next to me in the courtroom, so he was watching me scribble my notes, and I kind of watched his eyes get bigger and bigger and bigger as I kept flipping pages. And by the time I'm 8 pages in, and we're not even at Mr. Baldwin's opening statement yet, I think he was maybe concerned for like the health of my hand. What can I say? I take a lot of notes. I'm a little OCD like that. ACV, taking all of those notes took a lot of work. Thank you for doing the media's job and also for being objective. Well, you're very welcome. I'm doing my best to report the facts as facts. I mean, I feel like one thing I'm really good at as a lawyer is knowing the difference between what's a fact and what's an opinion. Yes, there are some small areas where there's a fine distinction between those two things, but usually it's pretty easy to tell the difference. And so what people are testifying to, the things that they said, this is the bulk of the case and what people are interested in, right? The evidence coming out. My opinions and analysis about the process and kind of how I think things are going and stuff. I know that's not what everybody is here for. I know that's not stuff that everybody is going to find interesting, but a lot of people do. I think a lot of people find it interesting to look at cases from the lawyer's perspective and just how that works. Like I keep saying, my opinion is just my opinion. You can take it for what you want, for what value you think it has. But I do try to be objective. I certainly have a bias. I'm a defense lawyer. Been a defense lawyer my entire career. I've never been a prosecutor. That's how I've handled cases. That's how I've interacted with these situations. So that's what I can relate to and understand. It's where my insight is going to come from. I've never, not having been a prosecutor, it's much harder for me to put myself in their shoes and kind of, do their job. But I do try to be fair. I don't have an agenda, just here to call it like I see it. So yeah, I thought Mr. McClelland did a very good job today. I think he's a good lawyer. I thought that his opening in many ways was probably better than Mr. Baldwin's. Not that Mr. Baldwin's opening was bad by any means, but what Mr. McClelland had that Mr. Baldwin didn't is he had that unifying theme, that one thing that kind of tied it all together. Bullet bridge guy, brutal murder of two little girls. It's not necessarily a great theme, but at least it's something, and it's the thing that he can keep circling back to. Mr. Baldwin really didn't have a unifying theme, and so it did lead to his opening potentially coming across as maybe a little rambling, just disorganized, a lot of information and good information, and the jury was very attentive to what he was saying. But just in terms of turning the opening statement into a persuasive exercise, I'm not sure that he necessarily nailed that. But this is day one. There's a lot of trial to go from here. All kinds of things can change. And like I said, by no means do I think he did a bad job at all. But Mr. McClelland was strong, and that's just the reality of the situation. And on and on. You rock. Thank you so much for everything. Well, thank you. I appreciate that. It's like I said, it's been really awesome just getting all this feedback from people I'm meeting that watch what I do and have nice things to say about it and stuff like that. It's still quite odd for me because, I'm just me. I'm just a person who talks, and for some reason all these people find it interesting. So it's very cool for me that all of you think that, and I really do appreciate it. Lori Lee Annie, thank you for covering, Andrea. Mods, chat is easier if you turn on subscribers only mode. Have a great weekend. We can chat about that. I've never used the subscribers only mode, mainly just because I like a free flowing chat. I like a busy chat. I like a lot of different opinions. I don't necessarily, want people to have to subscribe to me if they don't want to. I don't mind, people drive by checking it out and seeing what they have to say. But if things do get a little out of hand, we can maybe consider that to help slow it down. St. Simon Trent, thank you so much for all of the work you are doing on this case. Buy yourself a breaded tenderloin while you are here in Indiana. Well, thank you so much. I'm sorry to tell you, I haven't eaten a mammal in 18 years, I think. I've been mostly vegetarian since law school. I will eat some fish and pescatarian. So I will not be having the breaded tenderloin, but I will find something good that I can enjoy. I promise you that. What was somebody telling me about? Somebody was telling me about, I think, like a shrimp cocktail. Somebody has like an amazing shrimp cocktail. I got to go back through the comments and find that one. I think it was maybe down towards Indy, but I'll have to check it out. Arla 7247. Different jurisdictions, different rules. It seems this could possibly affect the outcome. Yeah, I mean, that's one of the things about following these cases from all over the country, constantly learning all of these idiosyncrasies of different places. Of course, you never think your own jurisdiction is the weird one, right? We're perfectly normal where I do things. It's everybody else that's the weirdo. This is just some unusual stuff. You know, I haven't run into it before. It doesn't mean, you know, doesn't mean it's weird, doesn't mean it's awful or anything like that, but I just notice it because it is so different. The jury conversation stuff, the talking about the exhibits, that one I don't really like that, you know, for just design reasons about how deliberations are supposed to work. It seems to really undermine that. But this whole issue with may convict versus shall acquit, I like that. I like that a lot. I mean, I think that's really how it should be. I think that mercy is an important part of the decision-making process. But at the same time, it's a fine line. You know, it's a fine line. A lot of injustice has been perpetrated through the mechanism of jury nullification. I'm not necessarily an advocate for that. So, yeah, a little gray area, but it is interesting to have that little bit of flex there, just for the situation where, yeah, the law is unfair. Applying the law is unfair. Buru berries. How can the defense overcome the graphic case details, maybe pushing jurors to guilty because they want someone to go away so that makes them feel safer compared to not having a conclusion? Guys, if you subscribe to my Substack, if you're a paid subscriber to my Substack, I did a video about this over the last couple days, and I left it there and I'm leaving it there because it is the kind of conversation that it's I don't want to say personal, but it is. It's philosophical. It's getting into some of my kind of deeper core beliefs and thoughts and things like that. But this is really a lot of what I'm talking about in that. Because yes, the jurors are very naturally going to have a strong incentive, not just to put somebody away so that they feel safe, but they want to comfort that family. They want to give justice to that family. They want to make them feel like justice has been done, give them closure so that they could move on. And not just that, but they realize like if they can't reach a verdict, they know what that means for the family, that they're going to have to do this again. They're going to have to do this again. And if they acquit Mr. Allen, then they know that they've gone through all of this for nothing. All of it for nothing. That the best case scenario is the family has to go through it again. The worst case scenario is they never go through it again because they never find anybody else and they never get that closure. And that is an extremely difficult prospect for people to contemplate when you're thinking about your vote and the implications of your vote on that jury. So yeah, it's an enormous amount of pressure. I hope that they deal with it in their closing. It would have been nice in a perfect world to have seen some of that fleshed out a little bit in the jury selection and the voir dire to prepare them for the fact that you might need to make a decision that is hard, that you don't want to make, that you may recognize is going to cause pain to these families. You may need to make a decision that is going to cause these families pain because it's the right thing to do. It's hard. That is a hard thing to do. So I do hope that they address that in their closing in some way to just prepare them for that responsibility and what that means. You know, look it in the eye and not shy away from it. Confront it head on. Because yeah, that is extremely difficult to get past. Daniel Cole with a $20 super chat. Thank you so much. Really appreciate that. La Kong Express, you are our media mailboxes. Well, thank you. What an honor to be in that role. Claude Simeon, really admire you, eloquent, knowledgeable, and fierce. Well, thank you so much. Those are awfully nice compliments for you to give me. I just don't like to take any shit, and I don't like when people think they're above the rules, especially the people that are supposed to be enforcing them, the ones that are supposed to make sure that the rest of us are following the rules and they don't respect the rules. It makes me angry. TB85. Oh, you really pulled me in completely today, Andrea. Thank you. Well, you're very welcome. It felt to me like I was talking an awful lot, but there was a lot that happened today, so many details, and I wanted to make sure to be able to communicate that to all of you, because I know for a lot of you, especially who have been following this case for so long, the devil is in the details. Like, I get it. I get how important the details are in this case. So that's why I know it's really important to track them. And that is the thing that we, the content creators, the new media, that's what we provide that the traditional media doesn't. The traditional media is going to have maybe a 5-minute segment where they will give you essentially the overview that I gave you at the very top. The composites are out. There's no real bombshells. The hair might belong to Libby's sister. Becky Patty broke my heart. And the media, the photographers got kicked out of the courtroom. Like, that's probably what you're going to get from mainstream media. But I know that there's so much more to this case when you really get drilling down into the details, because that's where we're going to find truth or falsity, innocence or guilt. That's where it's gonna reside. Sarita Banana, do not answer questions. Shut down the computer and take off the bra and sleep. Thank you, Andrea. Well, there's not super too many left, so thank you for that permission. I do appreciate it. I'm going to do it very quickly here. Julie, thanks for the recap, Andrea. Please get some sleep. It's going to be a long, crazy trial. It is indeed. I will sleep on the plane tomorrow, I promise. Lindsay Bay with a $9.99 super chat. Thank you so much. And Jojo with a $20 super sticker. That is awesome. You guys are amazing. Thank you so much for all of your support. Thank you for continuing to show up here night after night. Look at this. There's 3,000 of you in here. I've been talking for hours and all of you are here. This is amazing and incredible. I'm really blown away, and I'm honored that you choose my perspective to follow, and that you trust me to give you this information about this trial that all of us care about so much. So I will miss tomorrow, unfortunately. So I will be doing the catching up on the replays with everybody else. I'll be checking in with Lawyer Lee and Bob Motta, Defense Diaries, and all those folks to get my recap from them, and get up to speed about what happens while I'm gone. But I will plan to be back bright and early in that line Monday morning and see what we have next coming up in the case. I'm expecting we're going to have quite a while of the state's case before we get to the defense. A couple weeks probably. Hard to say, who knows, but the defense witness list outnumbered the state's witness list close to 3-1, almost 3-1, 130-ish witnesses to 50-ish witnesses. So we're 5 witnesses in at the close of the day today. That's actually not too bad. It's not a bad pace. Somebody asked me on the way out if from my perspective as a lawyer, is this really dragging? Is this going really slow? Like, no, I'd say it's pretty normal. I wouldn't say they're going crazy fast or anything like that, but it seems like about a normal pace of trial. So they'll get through more than 5 witnesses, potentially, because they don't have the openings to take up. On the other hand, some of the witnesses are going to take a lot more time, but if they can keep up that kind of pace, then yeah, I think, this trial isn't necessarily gonna drag on for any absolutely ridiculous length of time. Gianna, you had me at vegetarian, and I very much appreciate your detailed and comprehensive coverage of this case. I did say mostly. I did say mostly. I'm a tall girl. I have a hard time getting by without some fish, but yeah, I don't eat my chickens. That's why I got that darn rooster. Got a rooster I didn't expect, didn't particularly want, but gosh darn it, I can't make myself eat him. So around he stays, annoying the neighbors. Well, guys, I am going to go ahead and check out now. Appreciate all of you for being here with me. Thank you so much. Thank you to the mods for everything that you do. You guys have been such an enormous help. Just all kinds of stuff behind the scenes besides the work here in the stream, helping me out with sharing the link around and helping me get some images together for thumbnails and things like that. Just a really wonderful team. Obviously, my husband, who does more than anybody. He's taking care of my dogs and my chickens and my bonsai trees and all that while I'm gone, and leaving him by himself, by his lonesome, my lonely mod back at home now. So it's a great team that we have here. I love our scene. Thanks for contributing to it, for being a part of it. I'll look forward to seeing you guys back on Monday. Fingers crossed. We're all hoping that the crowd will start to thin out as time goes on, and then maybe just the interest will fade, because the openings, of course, are very exciting, but as you start getting into more and more of the details, it's less interesting to casual watchers. So we're hoping that that will start to ease up a little bit, and then maybe we can all get a little bit more sleep. But I'm going to be there bright and early Monday, just in case. So keep your fingers crossed for me, guys. Going to do my best to get in. I will get back to you no matter what, and let you know what happens. And yeah, just we got more coming in here, guys. Real quick, you're not going to let me go. Rochelle D with the pub halibut fish and chip fun. Perfect. I love halibut fish and chips. One of my favorite things. And then a super sticker from Starlight Selenite. Thank you so much. Really appreciate your support. Have a good night, guys. I'm going to get some sleep if I can, if I'm not too spun up to be able to sleep. I hope I can sleep, because got to get up early tomorrow. Wish my girl some luck in her fight. She's going to do awesome. I can't wait. I can't wait. It's going to be awesome. Well worth the trip. I will see you guys on Monday. Thank you so much, and please take care. Have a great weekend.